Are you ready?
First, ini mas akuluki nasoku, imas akuluki coração, também mas ligo na minha senhora, por mais mais santo, agar concede, tanto de bem e bem, e cultura, e linguagem, e aire, e cantar e encher cultura, sua história, estilo, e os deveres,
Chair Commissioners, we had the blessings of Mr. Isaac and Ms. Maha, who are our summer interns.
Okay, this meeting is now out to order.
Madam Chair, we can stop for a minute, or the audio is causing an issue, let me just grab some. Okay. Okay, we'll try this. I'll be sending it. Lydia. Lydia, can you speak? Mr. Pierce. Yeah, he's on. Mr. Camacho, can you hear us?
No audio.
Yes, I can hear you now. Yes, I can hear you now. Thank you very much. Can you guys hear me?
Yes, we can hear you. Thank you.
Okay, thank you. I will put me on mute because I'm at home. Thank you very much.
Thank you. No, her mic isn't working. But she can hear us. Did she see it? No.
I'm right here.
Oh, Mr. Pierce. Someone's wanting to, oh, there he is. Commissioner Thomas. You see it?
there he is.
Testing 1, 2, 3. Can you hear me?
Yes, we can hear you, we can hear you.
Okay, thank you. Thank you, Birch. You can just close the door now. Even if you were not. Okay, I'm ready.
Good?
Yes, you can go on. Okay. Thank you.
This is the CHamoru Land Trust Commission regular board meeting, Thursday, June 19, 2025. The time is 1:14 in the afternoon. This meeting is now called to order. Attendance, starting with Commissioner Earl Garrido, Commissioner Fabian, Ms. Fisher,
Present.
Commissioner Jeremy Rojas,
Present.
Commissioner Joseph Arcelo Cameron,
Present.
acting Assistant Director, Administrative Director Joseph Cruz.
President.
The public notice requirements were posted in the Guam Daily Post on June 12, 2025, and June 17, 2025. The Guam Public Notice website. Approval of the minutes of May 8, the regular board meeting. Are there any questions on? Sorry, I didn't identify myself. Arlene Verdali, Chairman.
I make a motion to accept the meeting, regular board meeting minutes of May 8, 2025.
Second.
All in favor, say aye.
Aye.
Aye. Motion carried. And now the approval of minutes of May 22nd, 2025.
I'll go ahead and make a motion to approve that minutes, subject to any errors or corrections.
Second.
All in favor, say aye.
Aye.
Motion carried. The administrative director's report, Mr. Please.
Hello? Can hear you.
Hello?
He's trying to mute himself. Thank you.
Okay.
Madam Chair, Commissioners, the first item we will report in the director's report is related to administrative. The first item is CLTC's invitation for bid for our office space has been canceled due to the increase in our needs. We are working on the updated specs and we plan to publish another IFB with GSA in October 2025. Any procurement of IFBs, the system has closed and it will reopen in October. The next item is CLTC will be submitting a letter to the Office of Insular Affairs requesting for a no-cost extension of 1 year related to our CLTC TAP grant that has been awarded. The funds from this grant will be used to upgrade our IT infrastructure. As we discussed in previous board meetings, maybe not with the current board, the funds will be used to scan, digitize, and index all our documents. It will also be used to create a end-user software similar to, but not as sophisticated as the land rep with BLM, where constituents can access and view their information that we have in file. Again, we'll be requesting for a 1 year no-cost extension. The next item is something we would like to bring up for the board to consider. Consider creating subcommittees such as a commercial subcommittee, a financial subcommittee, an agriculture residential subcommittee, and a compliance subcommittee. We feel that the presence of a board member may assist in the understanding that or the information we do provide to the board, and may streamline like decision makings for as long as there's a board presence and a board member participation. The next item is the residential and agriculture matters. The next 25 applicants in line for lease award publication has been delayed due to one of the applicants who we view has some legal matters that need to be addressed. We will be meeting with Attorney Miller tomorrow in the afternoon to discuss the legal way forward. Insofar as the FY 2025 $9 million appropriation, the draft MOA between CLTC and DLM was emailed to Mr. Joseph Borja yesterday. We do have a scheduled meeting to meet with Mr. Borja to discuss the MOA on Tuesday next week, June 24, 2025. In relation to GPA, we did meet with Mr. Vince Sablan and Ms. Josie Uggan to discuss the projected costs and projects. Just today, a amended projected cost has been submitted, although I just spoke to Ms. Uggan and we'll meet sometime next week to discuss further. As far as GWA is concerned, we did send an email to Mr. Bergalio requesting to meet with him. However, Mr. Bergalio is out of the office, but we anticipate to meet with him also next week. The last item is DPW. I will be meeting with the permit administrator of DPW to discuss any permitting requirements that we may need, that we may potentially need to clear the easements. The next item is the commercial. I know in the last meeting, or the meeting before, we did bring up the concern about the unauthorized use of submerged lands in PD. On June 12th, Deputy Attorney General Miller and myself met with Attorney Martinez, legal counsel for Tata Communications, and Mr. Lang from Tata Communications to discuss the issue of the unauthorized use of submerged lands in PD. We'll be providing a more updated report in the next meeting and the discussions that occurred. That's all for the directorship.
Madam Chair, this is Jojo. I was wondering if there was an opportunity to bring onto our agenda first for GPA. Mr. Cruz, is anybody from GPA there?
Yes, Ms. Josie Uggan is present.
Yes, I'm just wondering if I could make a motion to have them be heard. I think they're on a time crunch and they're just here for our meeting for momentary.
They're actually next on the agenda.
Thank you.
Ms. Cruz, I don't,
Oh, do you have to second it? Or is that the motion?
it's actually in the agenda.
So this has been approved already? Or we just went through this? We don't need to talk about it. I don't know. You know what I'm saying, is we don't need to talk about it. We just, we don't need to discuss your director's report?
subject to discussion?
Do you guys have any discussions or any questions?
About your report? I do. under item 2A, why do we hold up for one applicant for the next 25 applicants? If there's 25, why can't we continue with,
We're processing in the order it was received,
okay,
so we don't prematurely bypass. I believe the number one of the next 25 is the one we have an issue with
oh,
currently.
I see. Because so she's the actual next one in line.
Correct.
So how long would you say it's gonna take to clear up the matter?
By tomorrow afternoon, it should be
Okay,
resolved.
just one more day.
Yes.
Okay, Ms. Josie Ogden is here from the Guam Power Authority. Commissioner Cameron, she's here to speak.
How's the day? We're here to, previously, your May 8th board meeting, we presented a request for an easement in the Ukido area on that lot 10171, I believe. The immediate need for that was based on tampering. The tamper was really creative, 8 times. And we looked at it and we said, okay, we need to address this right away. And our first plan was to obtain those easements because as well as if you look at the initial plan, on this one here, we had also removed the meter at the lessee's lot. So we said, let's take care of this because we didn't want anyone hurt. The pole that was servicing, I believe, St. Augustine in the back was about to fall. That was the immediate need at that time, and I believe there was a delay up until the May 8th approval. Between that time, and I do have a summary there, things had changed. The tamper that was there, we don't know who it is. I moved out and somebody else had gone in and is using a generator. So we took that opportunity to say, okay, this whole area, we don't even have an easement for that proposed right of way, because it is only proposed. We don't have data on how wide it is, we don't have bearings, coordinates, or anything, not even for the lots.
I'm
So
sorry,
it's
Miss
still proposed.
Again, can you please let me know, what are you referring to with regard to what we have on the commission so that we can
Okay.
follow?
You have it?
I'm not sure, hold on just a minute.
Should be in the
That?
packet.
Okay, just a minute, let us get there.
Okay, that's the
This
initial
one.
request that got approved in May 8th.
So this is the initial request that was
Right.
approved on May 8th, okay. And so, continue, what are you referring to?
So now what's happened is the tamper that was here, and with this request, it was an immediate need to address the safety of the tenants around, as
Right.
well as the personnel to respond to anything out there. Up and from January to May, things had changed. The culprit or the tamperer had left the premise. And whoever is leasing that property has allowed someone else to go in there and they're using a generator, so it's a different person there.
Okay, but is that CLTC land when you're saying whoever's leasing that property?
All
It
this
is?
is CLCC.
Do we know who that person is?
We have a name in file, we did do our due diligence to contact, we have conducted site inspections. Unfortunately, when we do go there, nobody decides to come out.
Yeah.
We have made many attempts. Now what we're doing is the next visitation or inspection that's conducted will be a compliance inspection to trigger the requirement for them to come into compliance. And we'll go through that whole process where they're given 1 year to remediate. If not, we'll bring it to the board for determination of their
So,
lease.
I guess for that particular lot, the person that's currently staying there, are they the CLTC leaseholder?
We have not yet to verify because like I mentioned, when we go there, nobody comes out. We honk, we bang on whatever door is there, and nobody comes
So
out.
do you have record of notice? You can't, what is our next step? Like if, see, what is your next step? Do you post something that says if you don't contact our office by this date, we will take some action?
We do post notice to contact the office. Unfortunately, no one has called back yet. But like I mentioned, our next site visit will be a compliance inspection, which will be done next week as we schedule. We have it scheduled. And then we'll issue a notice to remediate to the last known lessee or lessee on record,
And how much time after that do they have to,
1 year.
1 year?
By law, 1 year they have to remediate.
So do they have running water on that property?
That I'm not sure.
You don't know, okay. I'm just, I guess, I just want to be clear as to how someone can be on CLTC land and we're not sure who they are. Okay.
So, in saying that, this was the first, approval by the board on May 8th for the easement that would have addressed the immediate concern. But now that tamperer, we'll say the culprit, is gone, we looked at it and we said, okay, let's do this, let's improve it at our cost, which basically will be from here all the way here. Because what we're doing is also changing out wood poles. We're hardening the area. Our issue is that everything here is based on a master plan. So we don't have distances, we don't have bearings, we don't have width. So we would like to rescind this first request, the initial request.
The request that was approved for easement
Yes.
1 and 2 at the last meeting?
Yes.
Okay.
And I know I have a lot of documents for you,
That's
but
okay,
I
we
wanted
can
to-
follow.
Yeah, and if we go here, this red is the whole proposed right of way. It's just proposed, it hasn't been conveyed or anything like that. And anything in the red is what we are looking at to, requesting for an easement to GPA to bring, to break the line and continue service to the tenant back here, or lessee back here. Okay, that's the whole thing. Now, if you look at this, we like to bring up that this easement, proposed right of way, doesn't connect to the bottom here,
Hold on just a minute.
okay?
Hold on.
Are you requesting for utility easement or right of way?
GPA easement, yes, just utility, we don't sever the easement for the government. We just wanna make sure that we have the right to occupy the area for troubleshooting, restoration, you know, new applicants and everything.
So currently, there's no easement, so what you're asking is to open the easement so we would reduce the property size. We would take a portion of the properties that this is lining to create the easement. Is that the ask?
Yes, what we are requesting is because it's not a conveyed easement.
Right.
There's no information in it, it was based on a master plan.
So there is no easement, that's what I'm saying.
Right.
There's no easement. So what
There's
you're
no-
asking is to take some footage from these properties where this red line is to create an easement.
Yes, which is the one here.
I wanna make sure I'm looking at the right map.
This is the option one, which is the best option actually. So, this is,
Hold on.
yeah, this
This one?
one preferred. Let me
Okay.
see what you have. I should have printed the bigger one out because of that.
It's okay.
So what it is this part, anything blue is existing,
Okay.
okay? Anything red is what we're going to upgrade.
That
At
you're
our-
going to what?
Upgrade at our cost.
Upgrade.
It's going to run along the proposed right-of-way.
Okay.
Based on the master plan, what we would like is to obtain a GPA easement only between CHamoru Land Trust and GPA. At a width of, we're asking minimum 15 up to 20. 20 only being that the bucket trucks, when they come in, the outriggers go out a little further. And in my years with GPA, dealing with land trust, we have had issues of being chased away, saying we didn't have a right to occupy.
Mhm.
Now we're protecting ourselves to say, yes, we do. This is between you, Chamorro Land Trust, that is the real landowner, and
Mhm.
GPA.
So when I look at this map, the lines that are drawn here where the red is, so that is actually already a right of way.
It's
that correct?
proposed,
Oh, proposed.
yes.
Okay.
And that's based on CLTC's master plan. that master plan doesn't have distances from lot to lot. Does it show the width of the proposed right of way? Now, we looked at this and we said, why don't we just remain there so that should at any time, you guys decide to actually set your property points, we're already residing there within your proposed right of way. When that happens and you do convey to the government, then that GPA easement will disappear.
So instead of 20, isn't the minimum footage to make an easement, is it 30 or 45 feet?
I believe 40.
So why don't we just do 40 feet? I mean, I don't want to come back 5 years or 10 years from now to say, oh, we need to access these lots. If we're already gonna do the easement for GPA, you might as well make it an access for new property owners or to access the property for other things like other utilities, sewer, what have you. We should do it all at one time.
Understood.
Okay.
Makes sense.
Is this, her request, line of request, is there any encumbrances or any?
No,
No.
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 Nothing that is in the way of this request, or there's no existing building, will it? When looking at this, it doesn't look like there are any homes, so it will not affect anyone's setback requirements with regard to their property lines, if we do 40 feet.
Initially, when the master plan was being created, which is just a tabletop, CLTC staff went out to start GPSing points of the existing tenants or lessees or occupants who are there. I believe this master plan was drawn and ensures that there is no encumbrances or anything in the way of severing out this as the actual easement when the time comes. Currently, it's accessible to those who are within the vicinity, within the area. There is currently enough room for the GPA bucket trucks to access. But again, I believe Ms. Alvin is requesting for the 15 to 20 feet for the lease properties that are along the pipeline. That's the GPA easement they're requesting for.
So
As
what-
well as within the proposed
Of the
right
right
of way.
So I would like to add that, just to go ahead and expand it to 40 feet to make it a true easement for any other utilities that the residents may need access to down the road. As this area becomes more populated, you know, I can imagine we'll have maybe buses going through there, you know, for families that live there, those type of things. So I think that when we create the easement, we should really think of the future of what are the other possible uses for the easement. But I wanna first make sure that if we create the 40 feet easement, that for the existing structures that are here, it won't render these structures, non-compliant with regard to, you know, the footage and everything, what they need to. So we need to look at that first.
So, on the cost for, we'll just stick with the preferred exhibit 1.
Okay?
GPA will pick up the cost, which includes our stakeout. Anything involved in the design is included in this cost, which is engineering design, PLS certification for the easement and the pole locations, as well as sending it to operations for the construction and removal of the entire line. That cost comes out to about $100,000 some dollars. If you look at exhibit 1 cost, and that's on our shoulders.
That also includes the clearing and any EP.
Well, the clearing,
So how are you gonna get in there if you're,
actually, how this was from previous supervisor, this design, the master plan was based on the Air Force right-of-way up there as an access. The only clearing we would have to do would be up on the top,
The lease portion.
the lease
so
portion.
that's what I'm saying, is there already 20
We
feet
would,
clearing?
we would do that as long as it's not, we don't open the road, but we clear enough for the bucket trucks and the line crew to safely do construction.
But will you open, if we're not gonna be able to do 40 feet, will you clear enough for 20 feet?
We will clear enough for bucket trucks, yes, to access the area.
Okay.
I have a lineman that used to. How wide would the
If
outlet
we're,
be? 20 feet?
is more than enough.
Yeah, 20.
if 40 feet is granted, will you clear enough for 40 feet? Could you
Sure.
add that into your cost?
Yes, because, actually that would be great with GK because of the flatbeds, the constant moving of the equipment within there. That's, can bring that up to
Please
our
make note
manager.
of that.
They have.
Add that to their cost.
I did.
No, that's, we do the survey,
Yes.
and we do have a contracted professional land surveyor that certifies everything, prepares the easement exhibit, and, all of that is embedded in this $100,000 cost.
Okay.
That's the poles, removing the line, everything else.
When you put in the concrete poles, would it diminish the ability of these illegal hookups?
I'm telling you, so a lot of these illegal hookups have been very creative.
No, but I mean, it's.
It will
it's-
not
it's-
diminish
it's-
it, we can't foresee who's gonna do it, but they will always find a way, yeah.
No, I was just thinking versus a wood pole, you know, you could.
Oh, yeah, the wood, cause it's easy to climb,
Yeah.
but, they
With
found
it.
ways with a concrete pole. They have, that's why I say they're very creative. It will minimize it, yes, can we stop it, I can't say. But, you know,
Does the commission have a copy of your documents that you're reading?
yes.
So is there verbiage, I don't see the verbiage here for all of your requests. Is it here? Because you're actually
I
asking,
did a short summary
okay.
of
and is
what
that-
happened in the beginning
that
to this,
this?
yeah.
Okay.
I don't know, is it?
So basically what you're asking is to reverse the decision from
Yes.
the last meeting for easement 1 and 2 that was approved. And you have a new ask, and is that spelled out here?
The, preferred
So
exhibit,
you want us to approve exhibit 1?
yeah, rescind the first and we can approve the preferred, which is exhibit 1, which is the cost of 100,000 plus 5,000 for our PLS, 105. It's a good deal.
Plus the additional cost to, increase to 40 feet if
No.
it's allowable.
No cost at all, because we would prepare it's a GPA easement between us and
Yes.
CLTC.
Just for clarification, so when the easement becomes a documented easement,
Yeah.
it will remove the floating
Yes, you
GPA
just
easement.
request to remove it,
Okay.
and it becomes a Government of Guam Public Utilities easement.
Thank you, that's exactly what I want. I want it to be a public utilities easement for all of the utilities, for all the residents in that area.
That'll work?
Will that work?
Oh, yeah, that'll work.
Okay, so, based on our discussion, I make a motion to rescind our previous motion and, approve the, GPA easement request labeled in Exhibit 1, to also take into consideration the expansion to 40 feet as mentioned by Commissioner Rospicio.
I second the motion.
Would that work for you? If we rescind the previous?
Oh, yes, yes, yes. Yeah, this is actually a good template for a lot of the CHamoru land trust properties where there are existing, facilities, right, especially their wood poles. A lot of it is because based on the master plan and it's not, the right of way wasn't conveyed over. So I think this is a good template of how we can approach a lot of these properties where we need to bring in the power. And these are the steps that we follow.
And I also noticed that we're not crossing boundaries into other properties, we're following along this line.
Right, when we do designs, we do try to make sure that, the property owner has full use of the property. In fact, you know, we won't put a pole right in the middle between the property points. Try to base it at the corners as best as we can with good engineering practice.
Thank you.
There's still the motion.
Yeah.
He made a motion and Cameron seconded.
All in favor, say aye.
Aye.
Thank you very much. So the last part is creating the easement.
Thank you.
Madam Chair, may I please request to make a motion?
What is your motion, Commissioner?
There are some bills at the legislature that requires us to just quickly go through. If we could move to D, E, F, G, H, I, and get that out of the way, then we'll come back to our old business and you.
Well, we have to follow our agenda because people are here right now attending this meeting and they come before G, E, and F.
I would yield to what the chair wishes to do, Madam Chair.
Thank you. Okay, continue.
The next item under old business is constituent matters. Mr. Jose Castro Munoz, who the board had conditionally or have gave instructions to his named successor, Ms. Carmen Leno, at the May 8, 2025 board meeting. The issue with this constituent is that the loan was foreclosed by the Guam Housing Corporation. Just to provide a little history, this is the lot, the loan on the lot that is unregistered. The board had instructed Ms. Meno to seek a pre-approval for a home loan with the Guam Housing Corporation. To our knowledge, she hasn't done so other than pick up an application. Also, CLTC, the staff and myself, we had prepared a letter in regards to the board's decision to memorialize it. We served it on two days, one at 3 p.m. and another at 6 p.m. at night. We've also attempted to mail it via certified mail. That was returned. Today, we're asking the board to rescind its decision of the conditional approval, and that we move and instruct or discuss with Guam Housing the next course of action. But just please be aware that the loan has already been foreclosed. If I'm not mistaken, it was also put out for bid. So if CLTC has any interest in that house, not the lot, in the house, consideration needs to be given for the redemption, to exercise the redemption. Currently, the redemption would only cost us what Guam Housing has or paid for. If any additional costs should arise, it's because of the eviction that they may have to serve to the people that are there, and then the real property taxes. So again, we're requesting the board to reconsider its conditional approval of granting Ms. Carmen Meno as the named successor due to non-compliance of the board's request of obtaining a pre-approval as required or requested on May 8, 2025.
So I see here that the request is also to cancel the lease and return the property back to the inventory for lease award. Is that right?
Well, eventually,
So-
as soon as we resolve all the foreclosure matters, automatically that property will be available for lease award. However, because it's unregistered, we're not gonna present it to the board for consideration to be leased. We must address the unregistered status of that property.
So should we cancel out number 3 then? It's in your request.
Yeah.
It's under, am I looking at the right one? Jose Castro Munoz request, item
Yes,
number
yes.
3. the first page.
Does that mean we're gonna render the property vacant?
Yes, for the property to be vacant. I apologize, I didn't prepare this report, I'm just presenting it as I oversee the loan guarantee program.
So basically, the request is just limited to item number 2.
Rescind.
I2.
Yes, because eventually we'll get to item 3. We'll come back to terminate the lease.
So the only thing we need is a motion to rescind the May 8th approval, right?
Correct.
I make a motion to rescind the May 8th approval that the CLTC Commission had made to allow Ms. Carmen Meno the opportunity to work with Guam Housing to get a loan and acquire the lease.
I second the motion.
I have a question. It's to rescind the request to name Carmen Meno as the successor of Jose Castro Munoz agricultural lease agreement. That's how.
Okay. I make a motion to rescind the May 8th request to name Carmen Meno the successor to Jose Castro Munoz's agricultural lease agreement.
I second that.
All in favor, say aye.
Aye.
Motion carried. Now we have Brian Rose, Evangelist.
The next item is Mr. Brian Mendiola. This again was presented to the board, I believe, on the May 8th meeting, where the board had approved the payment of $2,986.41 to the Guam Housing Corporation for the delinquent payments of Mr. Mendiola. However, when we went back to the loan guarantee and we referred back to the Chapter 75A in regards to curing a defaulted loan. Since Mr. Mendiola, we received a letter issued to Mr. Mendiola April 7th, dated April 7th. Mr. Mendiola, at least based on the loan guarantee and the requirements of the Act, should be given 60 days after the date of the letter to try to resolve his default status. Unfortunately, we've tried to contact Mr. Mendiola. I believe Mr. Mendiola has not attempted to communicate with the Guam Housing, so his 120 days in total was, or 60 days was June 6th. And still, up to today, Mr. Mendiola hasn't made any payments to our knowledge. So we're requesting the board to allow us to proceed with the actions needed to address the default. What will happen is, as it reads in the Chapter 75A, in the event of a loan default, the commission shall offer and reassign to the next qualified applicant the opportunity to assume any loan in default guaranteed by the beneficiary loan guarantee fund. The commission shall pursue this remedy to avert a loan default prior to making any direct payment of the loan and accrued interest with funds from the beneficiary loan guarantee fund. So, since we're already processing applications for lease award, we'll go back and identify who's the next in line from the previous 79 people or applications that have been processed. We definitely will refer them to the Guam Housing Corporation to to apply for or seek a pre-approval if possible, and then we'll work from there. But at the same time, we'll also discuss the matter with Attorney Miller. There is an eviction period, and I believe they're supposed to be granted a certain amount of time to vacate. But the legal aspect of that will be provided by Deputy Attorney General Miller.
So in order to bring the loan current, the outstanding balance is $4,977?
Correct. Ms. Edith Pangilinan, the president of Guam Housing, is present, if she can.
Thank you. Okay, so I know that Brian Mendola, we had reached out to him even as of yesterday through email and phone calls, and he didn't respond to any of our inquiries. So as of today, his payment is due at $5,933.52. $933.52.
What is the outstanding loan balance? Because that's just to bring it current, correct?
Yes, the outstanding loan balance is $134,000, and that's not including everything else, but that's at $134,409.17.
And then, of course, including everything, yeah.
Yeah.
Okay. So what we're paying, what the request is just to bring it current so that we can offer this loan balance and the property to the next,
Let's see.
based on your criteria through Guam Housing?
Yes.
Okay.
But if we bring this current, there's still gonna be a lag time until we get them out, right? So if he misses those payments, we're gonna have to make additional payments, is that correct?
We'll bring it again to the board for the July payment or August payment. But definitely we'll work hard and expeditiously to find the next person in line to take over the loan.
So when you say take over the loan, that is gonna include the amounts that CLTC has also settled?
Yes, I discussed with Attorney Miller if there's a possibility or an option where we can place a lien for the amount of money we're paying into the loan. But he hasn't provided me any final legal guidance on that, but that's something we were looking into.
Can we include that as part of the lease agreement?
We can discuss that with Attorney Miller.
Okay. There has to be a way to replenish those
recover.
funds.
Yes, ma'am.
Yes, to recover and replenish.
And then if another eligible lessee comes forward, they would have to get financing through Guam Housing, correct? Or USDA?
Guam
Okay.
Housing, the USDA, but I believe they package their loans, or VA loan.
Mhm.
Those are the only three.
Okay.
Those
So
are the
I guess I'm just getting at, we're limited on who,
Yes, sir.
yeah, okay. Who would be able to finance, right? Okay.
How many days is he actually in arrears?
Oh, actually, if we count, 60 days is usually when we refer it to CHamoru Land Trust. So that, because of the loan guarantee, right? And then, because we've tried to contact him and he's just not responding. However, this individual works for a government agency, so I don't see why he's not responding. He's not a good job to my knowledge, but just the fact that today he owes this amount of money and it adds up with late fees, right, on top of that. So it's up to,
So is it 60 days, 90 days?
now today, as of June 19th is the due date for the next payment, so it adds up. And we didn't even add the late fee for today. But the total that I read earlier, which was $5,933.52, is the balance that he owes.
I believe it's like a 5-month, he's over, how
Yeah,
many
it
months
must
has
be-
it?
Makes it 6 months today.
6 months.
Today.
Yeah.
6 months.
180.
Yeah.
Not a mess.
So we're requesting for the board for the approval to bring the loan current and pay $5,933.52. And also to commence the loan default remedy process.
seems that we've made all possible efforts to contact him, right?
Yes, sir.
Has he
So
been
are you
served?
asking for a motion to accept that?
Has he been served at his workplace?
No, because you see, you have to indicate that in your application that your workplace is, can be your last option, I guess, to go to.
So, just to provide some information to the question is, the last time we were able to speak with Mr. Mendiola, he made us aware that he's on swing shift. But when we did go back after our last discussion, he didn't come out. So, if it's 8 to 5, based on our last discussion with Mr. Mendiola, we won't find him at work. He'll be at home, because he works the swing shift.
Yeah, that's true. And that's where we encountered that there were dogs inside the house, and so, you know, you cannot go. They're afraid.
Even for us, we.
Our staff
park
have to
and
move away, you know.
honk.
Are you sure it's not a recording?
I don't know.
We didn't wanna find out it was us.
Right. We're afraid to go close. We just, when we heard the dogs, we were, move back, get into the car. So that's what happened. But for today, we're only asking, because of the loan guarantee that we have with CLTC, that the payment be made current, and then you have up to a year to find a lessee to
And
replace, I guess,
And if
whoever
I-
can assume.
if I may, in regards to the beneficiary loan guarantee fund information within the act, it reads, for the purpose of this section, a mortgage is considered in default when payments due upon the mortgage have not been satisfactorily tendered for a period of 120 calendar days. So we're at 6 months, which is 180 days, so we're well past that. We provided more than sufficient time.
What I don't get is, when you're gonna do a foreclosure, the money, pay it off. CLTC should not be the one paying the arrears. You should just foreclose the property. And then, since Mr. Mendiola did not pay his regular payments,
But it's calculated based on the payments.
no, but CLTC will pay the $134,000.
You wanna pay off the loan?
Yeah, and after 1 year, if Mr. Mendiola doesn't come and pay for it.
After 1 year, she's not saying right now.
Yeah. The loan
That's
guarantee.
right.
Yeah.
Well, in our.
That's normally the way things are done in
Yeah, I think our loan guarantee is a little bit different, and also in the chapter 75A, it reads, upon notification of the default of a loan guaranteed by the beneficiary loan guarantee fund, the commission shall, during the period pending reassignment of the loan or the determination of the commission to directly repay the loan and accrued interest due, bring current the payments due to the lender with the funds so reserved for such purposes in the beneficiary loan guarantee fund. The loan guarantee document itself also speaks to that, the commission does bring the loan current and continue to pay until such time a new lessee is able to assume the indebtedness of the loan. But I do understand, Madam Chair, where you're coming from. It's just, there's specific verbiage in the guarantee itself that requires CLTC to make the payments.
Okay, as it sounds, that's the way it's gonna go, so it's up to you to do the motion. To
My
pay.
question, I do have a question with regard to that though, because Mr. Mendiola has a mortgage. And so COTC is gonna bring it current, and we're gonna look for another lessee, but, are we gonna transfer the mortgage to the new lessee?
That's,
They have
Is
to
that- that's-
qualify.
that's how it
that-
works.
Okay.
Assume the,
Because, yeah, I mean, I guess in private banking, I'm just used to foreclosure happening.
right,
you
right.
know.
Understood.
Yeah, yeah.
This
So,
is
so
a
then the
different-
property's taken away from them in that way, right? So,
Yeah.
legally, right?
This is different, the property's not taken away.
Sure, okay.
It's on
Does,
lease mode.
does Mr. Mendiola have right of redemption?
No, right, he does not.
I can't
I don't
speak
think
to,
so.
that's.
That's why I'm asking.
Well,
I
It's the
think the
law,
lawyer
so
should
can you
check that
please
out.
clarify
Yeah.
that, of the right of redemption, because the right of
And
redemption
if
is
he
the law in
does,
any
when
foreclosure
did the clock
proceedings.
start for the right of redemption?
We can address that, but, because it's leasehold, that's the right of redemption, because of the leasehold, but we can,
We'll also, ask Attorney Miller if there's
Yeah.
Does Mr. Mendiola have a successor?
I believe so. If I'm
His
not
wife.
mistaken,
His wife.
Mr. Mendiola's wife, I
Yeah.
think is a co-borrower on the loan.
Should she be given an opportunity to?
Um,
I'm just asking because
Yeah, yeah.
she's on the documentation.
So what it is, our obligation is to our name lessee.
Right.
And to your question, we have encountered many situations like that, even with loans with SBA, where their common law is named on the loan, although they're not allowed to succeed the lease when the common law passes. But that's a legal question. I'll consult with Attorney Miller if the co-borrower has the opportunity, given that they're able to qualify for the program.
But
to-
if there is a named co-borrower or co-signer to the loan, that's what a co-borrower is, correct?
Yeah.
Isn't that going to ruin their credit rating also,
Yeah.
I believe so.
they're no
Technically,
longer
they're on-
together.
even though, but their signatures are guaranteeing the loan?
True, but
Technically, she's on
she
the
gave
hook,
up,
right?
she gave up her rights, because she knows that, I mean, I hate to bring this up because she's not CHamoru, right? And so she just kinda,
But did
Gave
she
up.
sign
She,
a waiver?
oh, I don't know about, I just know she's a co-borrower on the mortgage.
Okay,
Sorry.
so,
So did she sign the waiver to give up her rights for the loan? Because technically, she's the next person in line to resolve the loan.
true, you're correct on that. But, from my knowledge from my staff is that she had relinquished her rights. And so I need to provide that document, if indeed she signed that.
so based on that, even though she's a co-borrower, she won't be pursued
For the.
for the,
Have you attempted to collect from her?
We
I
did
think
try
that-
calling her, and she was the one in the beginning who was informing Mr. Mendiola to pay up. However, he did do that for the first couple of months, because this is before this really happened. And he did, but then after that, they were not amicable. She just was afraid to go there, and, or we tried to talk to him. So that's where that just kind of ended. And so the last word we got was that she releases her, whatever that she has to the loan. So we just need to get that in writing.
so,
I think we should refer this to the attorney and get more clarification from him, because it's not,
Yeah, she's
it's not
in a
that simple.
situation, but just the fact that it's,
But
it's,
for,
she's not entitled.
for this situation, maybe we should consider paying the arrears. But then again, I don't, I'm sorry, but I still feel more comfortable if we revert to Miller first.
To address the co-borrower situation?
Yes.
should we possibly table it and,
Yeah.
discuss it further with Attorney Miller?
That's okay, because it just keeps accruing anyhow.
It's got to keep adding, right?
Yeah.
Can Guam Housing cease all accrual of interest and penalties?
Oh, can't do.
I just thought I'd ask.
Well, I think,
But if that's the
yeah,
decision.
to Commissioner Garrido's point, it's really the responsibility of the lender to pursue every action as much as possible with regard to the co-borrower. We are the guarantor, we are not the borrower. So if we've already exhausted all means for the primary borrower, then you go to the co-borrower, and it doesn't seem, I'm not hearing that everything has been completely exhausted. You know, I mean, okay, maybe you talked to her a few times, but, you know, there has to be, I'm sure you have your own protocol in terms of collection proceedings, right?
Yeah.
So all collection proceedings that pertain to the primary borrower should also pertain to the secondary, the co-borrower, and I think that needs to be done before you come to look for the guarantor.
That's fine. You guys, this is your call to table it, and we'll come back with questions that are being raised, and we'll refer also to legal, because this is now beyond 60 days.
Yeah,
And if
because
action is not being taken pursuant to the guarantee with CLTC, then we're gonna have to go beyond you guys, which is our legal.
Yes.
We're not going anywhere, we're here. Don't worry.
We're not withdrawing
No,
our
I'm just
guarantee, we're
saying
saying
that
do
yeah.
take your protocol with the co-borrower, because it doesn't seem like you've done that.
We
Yeah.
did, she released her, all her rights to the loan. But again, that has to be legally accepted, I guess, with our attorney.
Yeah, so yeah.
Because, like I said, I
You have
don't
to
need to
exhaust
say the
all
word,
means with
No,
the
my
because
next
co-borrower.
they're no
question-
longer together.
Yeah, my next question is actually for our acting administrative director. If the co-signer is on the line for being responsible for the loan, if she decides to make the loan good, can we have her as the next stand-in?
Can she assume the lease?
Yeah,
No.
Well, I believe if they're married
But
and they get a divorce, if the divorce decree stipulates verbiage to that, there's a possibility, because she still has to be able to qualify for the program through the eligible beneficiary process.
but how would that affect her in this situation? Let's say it's a nasty divorce that they went through. I can see a good point for her to get even by assuming the loan.
she doesn't want
Right.
she doesn't want the house, that's the
There-
bottom line. She made it clear. She made it
But-
clear to our collection agent, she doesn't want to have anything to do with the house.
But to speak to your question, or to answer your question, there's a possibility. But nonetheless, the all be all is that she needs to qualify for the
For
program.
the program. And she's, I hate to
But
say
how
it.
would that affect it? See, because if she qualifies, she's gonna have to qualify at today's date and time.
Well, if she succeeds, so how it could work, right, is because if Mr. Mendiola had held the lease for a 7-year period, Mr. Mendiola is able to transfer that lease to another qualified eligible beneficiary. It could be done like that for as long as the person qualifies for the program. We have seen where there's divorce decrees that were submitted, and it was very detailed into the judge and order mentioning that the lease will be given to the spouse. We've seen that, and the spouse wasn't the original applicant, but they became co-applicants in the loan.
But also, Guam housing should not require the non-CHamoru to sign that promissory note.
Well, maybe that was the basis of their approval, maybe he needed her income in order to qualify,
No, but
you know, so.
if there's a certain rule in Chamorro Land Trust,
What we'll do is we'll go back and discuss the loan guarantee in its entirety with Attorney Miller, if any amendments can be made.
It sounds like all the questions
But
we have
also-
Yeah, the
kind
questions are
of
raised
go
now.
back to.
They're the-
But also
guarantee.
based on this particular situation, because this is not the ordinary type of
It's not.
condition.
You're right.
It's like I said, if she's willing to assume the loan because she's a co-borrower on it, can she become the new tenant? being that time and date is also a key factor in how we determine who's going to get the property.
So, there is a possibility, like I mentioned, but depending on Mr. Mendiola, if he's out for blood, right, he's not gonna wanna transfer his lease to his ex-wife. So,
Yeah,
there-
but she's a
there's-
co-signer on the property.
But nonetheless, we'll
Look into
get our
that.
legal guidance from,
Mhm.
but, Ms. Penguin, if we may, if you do have a relinquishment letter of the co-borrower's rights, if you can
Yeah,
provide us a
I'll
copy.
bring
and
that
we
for
can
the
put
next,
it in file and,
put it in the agenda for next board meeting.
correct. and
Because we
then
wanna resolve this,
We
right?
can also have our attorney look through all the documents.
Yeah,
So-
sure.
So the relinquishment of rights needs to be a proper legal document to say not only is she relinquishing, I mean, that she's completely relinquishing her entire rights to the property.
Yeah.
Because, to the Commissioner's Carrillo's point, if she doesn't relinquish her rights and she pays, she may want to go after the property, and this is what we're trying to avoid, because we already know that she's not next in line.
Yeah, and she knows that.
Yeah.
That's why she's releasing all her.
So
her
if
rights
we
to
have a
the-
legal, a proper legal document, not just a letter typed, it needs to be a proper legal document.
Are they divorced?
I'm sorry,
Are they divorced?
to my knowledge, yeah.
Were they
They are,
married?
I'm sorry.
Were they married?
She carries Manjola, so yeah,
Oh.
they're married.
So the divorce decree should say if she's liable for that.
And that's what you guys want to see.
Yeah,
If it
provide
needs, then that's there,
To our legal,
yeah,
So we can determine the avenue, what direction we can take.
sure. Oh, yeah.
This is Commissioner Cameron. I'm trying to follow all the discussions, but there's so many things being said all at once, it seems to me anyways. What is the end all on this situation? What does the commission want to do?
we're tabling it. And we're having
Asking so.
the lawyer look at this whole questions that we asked.
Non
Yeah,
guaranteed.
so I'd like to make a motion to table this, this subject to, until, for further legal review.
I second.
I second the motion.
All in favor, say aye.
Aye.
Communicating?
Come with you upstairs.
Questions, very good questions.
There's either B, typing,
Is she present? She's here. Thank you.
Good afternoon, Commissioners. My name is Glenn Aim, I'm 18 to be here. And the next constituent matter here for us is Mr. Sita Bar Taiting Fong. The original lessee is Joseph Taiting Fong, who's deceased, her late husband. And what she's doing right now today, she's requesting, she is the successor of her husband's lease. And the reason for her being here is she's requested to decrease the 5-acre lease that she has to a 1/2 acre. And also, in doing so, requesting that CLTC survey the property, the subject property, as part of the reduction. And also waive property tax for 2025. And also to accept the current building structure. Because we did a site inspection way back sometime and gave her 1 year to remediate. And she mentioned to me that the building was constructed a long time ago, and she doesn't know if that was a permit or if there any permit. And she's asking if they could waive the building structure as part of the, because there's no building permit to grandfather in. And so I'd like to explain the little event from the chronology that what happened, and starting at the second page, where what led us here today, starting from item number 8, July 7, 2021, Ms. Taiting Fong submitted a takeover and qualifying documents to succeed her husband's lease agreement. And she had notarized this letter of request to decrease the property size from 5 acre to 2 acre. And item number 10, November 27, 2023, she followed up with the request and to address the chairwoman Badano in regards to decrease her acreage and land taxes inquiry. February 15, 2024, Ms. Tyson Fong case was put into February agenda but tabled for resumption meeting. February 22nd, 2024, Ms. Tyson Fong case was tabled due to issues addressed on staff report mentioned by Commissioner Garrido, request to bring back the March meeting for reconsideration. And lastly, in number 14, February 2025, Administrative Director Cruz and Dede met with Tyson Fong to give over the findings from the compliance inspection. A letter of notice to remediate was issued to the Tyson Fong during the meeting with the CLTC staff. So she's here today, right now, like I mentioned, to requesting all these matters that I just addressed to you. And she wants, any questions you can address to Ms. Tyson Fong if you will. Or would you like to address, say anything to the commissioners?
If I may, Mr. Tyson Fong's lease fell within the category of a lease of a cloud, meaning I'm assuming that he may have been given a lease prior to his application date and time. However, Public Law 37-131 gave us that avenue to address those leases with clouds, those leases that were executed contrary to law, which is why a compliance inspection was conducted on the property that Mrs. Tyson Fong is currently staying on, and a notice to remediate was issued to Mrs. Tyson Fong, because she was also the main beneficiary for her husband. And I believe because the size of the property at 5 acres, Mrs. Tyson Fong has come to realize or accept that she will not be able to come into compliance with the 5 acre leased property, which is why her decision is to reduce it to ½ acre where it's more manageable and she will be able to qualify or to come into compliance with the requirements of a ½ acre. And because like Glenn had mentioned, and I had mentioned previously in the board meeting, I don't know if it's this board or the previous board, although we do have lessees who are currently on the property but were initially there through a older land lease program, whether it's the LUP, the Rendu, or whatever, the Department of Agriculture long-term lease. There is a structure, and if we go out there, or when we did go out there based on the lease terms and conditions, that's why I believe they're asking for the acceptance or the grandfathering of the current structure that's there, because it was constructed prior to the CLTC program commencing. So again, I believe that Ms. Tyson Fong is requesting for a reduction in acreage because she's accepted the fact that she won't be able to come into compliance and farm the whole 5 acres. So she's willing to reduce her acreage size.
But in the very beginning, in number 1 here, it says 5 acres to ½ an acre.
Currently, she has a lease for 5 acres. She wants to reduce it to a ½ acre so she can
Later on,
manage.
it's requesting for 2 acres.
Well, initially, when she first came in, prior to like 2021, she wanted to reduce it to 2 acre. And then after, further discussion with Ms. Tyson Fong, she goes, wait a minute, at my age and everything, I don't think I'm able to farm 2 acre. I want to she's sure that she can manage a ½ acre. And that's why she came here today, requesting to reduce it from a 2 acre to a ½ acre.
I believe that's
Okay,
and the
so it's
summary
a ½ acre.
It's a ½ acre
Target
now.
is ½ acre.
Right, yeah.
In the summary section that you're referring to, the next paragraph speaks to the half.
Okay.
I have no problem with the ½ acre. It's agriculture, you have to farm on 2/3 of the ½ acre, so it's something I believe that you would be able to do.
So
If
am I
you- if you haven't
understanding, this is
already
Commissioner
started.
Cameron, am I understanding that the request of Teresita B. Taikifo, be considered the next, individual as a result of the death of her husband? But that lot that the husband had, leased with us, she's requesting for less acreage or less square meters?
She's requesting to reduce it from 5 acres to 1/2 acre.
Is that a problem, Mr.
No.
No, it isn't, no.
I just wanna, be sure that, with regard to the request, because we don't have a map, that if we reduce from 5 to 1/2 acre, that because there's already an existing building, that we respect the Guam law with regard to setbacks.
Yeah.
So however we design, or however we cut back that 5 to 1/2 acre, it needs to be in a way where her building does not violate the
setback
Guam
requirements,
setback
yes.
rules.
We had discussed that with, I think, Fong, that because her building we're situated right now, it's in the middle,
Yes.
towards the front. And so we're gonna have our tank, and go up there and GPS first, the building, location, everything, make sure that the setback requirements are put into place before we, recommended the 1/2 acre. It may be more than a half acre, or maybe just 1/2 acre. We're not sure yet, but based on the building size, I think it's doable to make that for a 1/2 acre.
Commissioner Ross, Mr. Bishop, if I may add to it. So what will happen, as Glenn had mentioned about the GPSing, our planner two will also develop a scheme for the area. Definitely, the scheme will not disrupt or prevent Ms. Taikifong's current structure from not complying with the setbacks.
So I would like to go ahead and make a motion to approve her request pending all the other idiosyncrasies that we need to do just to make that happen. So that's my motion. Notwithstanding all the other discussions that are ongoing, I would like to make the motion to approve her request.
Can I interject, please, before we go into the motion? There's part of the request is also to basically grandfather
The structure.
the structure, and I think that's outside of our purview. That should fall under public works, building permits.
So what it
So
is,
you're asking me to go ahead and amend my motion to accept the waiver?
I don't think we can waiver it.
it's not necessarily to exempt her from the building codes that are required, although what's required within our lease terms and conditions is that the lessee complies with all territorial and building laws. But because her structure was erected prior to a certain period, or even to the existence of CHamoru Trust, through another land use program, she won't be able to provide us with any permitting. I don't believe she'll be able to provide us with any permits. But what we will do is that when I do meet with the permit administrator tomorrow at 1 p.m. from DPW, I can inquire about a situation just like Ms. Taikifong and every other lessee we may have.
So I think the only thing we could do would be to, as far as an acceptance, would just be to say that it meets our requirements for any building that should have been built as part, during the term of the lease, right? We can't say we can't make any requirements as to whether or not it meets building code.
Correct.
So we cannot technically say we are accepting the current building structure, because we don't know the soundness of the building, we don't know, we can't speak to any of that, so, to Commissioner Rojas' point, it's only to accept that it meets our standard.
To acknowledge, I guess,
Right.
for the
Yeah.
existence.
Just to acknowledge it.
Right,
We
for the
cannot-
purpose of the lease.
Yes.
Right, not to accept it.
So my motion is still standing. I would like to move to accept her request.
How do you modify that motion?
Wait a minute.
There's several items there that she's
Yeah.
requesting there that.
So,
Right.
I know,
Do number one,
so number one is the
Yeah.
decrease from 5 to 1/2 acre.
right.
That's the first request.
Right.
so do, make the motion for that.
So Commissioner Cameron, are you doing a motion for request number 1 and number 2, or just?
Yes, I'm doing for 1 and 2.
Well, we have to
4.
do one at a time.
Okay, or 1 and 4.
Okay, so we'll go ahead and make then the motion for the number 1 request.
I second the motion.
From 5 acres to half an
Half
acre.
acre.
Yes,
Second by,
I second the motion.
all in favor, say aye.
Aye.
Right.
Number 2,
Ms. Tai Ting Fong is requesting the government to survey the half-acre property.
Is that normally what CLTC does? Is that normally within our, okay, so then why would we make an exception?
Not we're asking, we're gonna allow the board to decide.
Isn't the cost that's burdened on the
Yeah,
survey is to eventually to Mrs. Teresita be taken from?
Normally, our constituents shoulder the cost for survey.
Yes, and so right now, that's the issue on number 2.
That's her request. She wanted to ask if the government can consider survey.
well,
And that
first
she
of
will
all,
accept the cost for the survey?
She wants CHamoru to pay for the cost of survey.
let me ask the question. The 5 acres, who surveyed that?
Right now, that property hasn't been surveyed since they were issued the lease, pending survey. That's why we don't have a map right now to show you right now, but we have a preliminary map that shows the proximity and everything about the map, but it hasn't been surveyed. To answer your question, it hasn't been surveyed yet.
The only thing that has been created is a subdivision master plan, which is a tabletop. No actual horizontal survey has been completed.
So the motion that I would like, that I was making earlier, I withdraw my motion. It sounds like there's a lot more work that needs to be done with number 2 before we can make a motion to accept. So I'm withdrawing my any motion on number 2.
that's right.
It could be tabled
Yeah.
or if it's not an outright denial, it could be tabled. But nonetheless, even if CLTC did not agree to covering the cost of the survey, which is really shouldered by our constituents, in order for Ms. Tai Ting Fong to come into compliance, she's gonna have to survey the property, because it's a subject to survey.
That's what I understand.
So
Maybe she's just not aware that that's what should happen.
I don't think that we should steer from any CLTC rules or guidelines with regard to surveying and waiving any
Taxes.
fees or taxes. I think that, we open up a huge can of worms. Also because if we make a decision today, what about everything prior?
Understood.
So I'm not in agreement to item number 2 and 3.
Okay,
I
so
don't
move
feel
to
that
4.
we're not in the position to waive any fees.
So-
Okay, can I say something, please? The year is already coming to an end, and I have provided the commission with the death certificate of my husband since the day that, the year that he passed away. I've paid all of those taxes, updated everything, and as I said, the year is coming to an end. I'm gonna pay for the whole 5 again, and which I already asked, requesting for this, deduction of acreage.
But you're asking for a reduction which is out of the ordinary. I could probably understand if this was a brand-new lease, maybe we could have shouldered the cost for the survey. Okay, but your lease already entails 5 acres, and you want a reduction from 5 acres to half an acre. So that in itself should be burdened by the tenant, which is, in this case, you. I don't know how long your lease is for, but since the request is to reduce it from 5 acres, which was the actual lease, to half an acre. Any work that would be done for that should be burdened by the tenant, which is you. If you're saying like there's only 5 years left on your 99-year lease, then why would you wanna do it? Just give up the lease. You get what I'm saying?
I understand,
Hmm.
but
I'm not trying to be hard on you or anything like that, but, you know, the facts remain that your lease is 5 years, you're asking for reduction, and you're also asking for us to pay for the survey for your reduction. And, it's the public's money that we're here to, determine. If we make an exception for you, there's a lot of other people
Open up the
also
can
that
of
are
worms.
asking for a reduction in, property size.
I sense that, I'm very cautious about this, because, if we grant her that that the commission is going to pay for the survey, this will open up a can of worms, and it'll be everybody else. Everybody else are gonna ask for that, and we're gonna shoulder from now on, something that we've never done before, to my knowledge, is that we pay for somebody's survey.
Also, with regard to waiving the taxes, at the time that the lease was signed, it was the tenant, request for the 5 acres, is that right? So at the time that you requested the 5 acres, you already, the tenants understand that they will be responsible for the taxes, et cetera. So until the land size is reduced, then you will pay taxes according to the land size.
I think if
I
we're,
think we're impasse here. I'd like to go back to the earlier discussion that, the survey has to be done by you.
I'm sorry, Commissioner, I was actually also referring to item number 3, so with regard to item number 2 and number 3, which is survey and taxes.
actually, just looking at all three, I think one way we could do it is to say that we could decrease the acreage from 5 to 1/2 acre, subject to the lessee paying for a survey, and maybe the taxes could be prorated up until the point where the property's cut.
Okay.
Is that your motion?
Yeah, I guess I'll make a motion to decrease the acreage from 5 acres to 1/2 acre, subject to the lessee conducting a survey of the property to reduce, you know, to identify the 1/2 acre, which would also include the structure. And the property tax could be considered, or we could consider to prorate the tax up until the point where the property is subdivided.
Consider or approve, because I don't agree.
Well, I guess, okay, so let me restate it. I make a motion to decrease the acreage from 5 acres to 1/2 acres, subject to the lessee paying for a survey to identify the 1/2 acre property and prorate the 2025 taxes up to the point where the property is subdivided. And to address number 4, to accept the current building structure only with regard to the CLTC's requirement, not to any permitting or any other building codes.
Just if I may, I do apologize, Commissioner Rollins, but any proration of taxes will be determined by
Right.
revenue tax.
Right.
So I don't know if the property should stay at 5 acres for 7 months of the year, she may automatically have to pay for the entire year.
Okay.
So,
Well,
just-
maybe subject to DRT's determination.
Yeah.
So, just so that I may also, I don't agree with regard to the proration of taxes, because the property, the 4 1/2 acres that she would like to relinquish is still unusable to anyone else, because it's still stuck as part of her lease. So because it's still stuck as part of her lease, she still has rights to that property, so therefore the tenant must pay the taxes on the entire parcel.
So would you like
So
to
how do I
request an
amend that,
amendment to
or I'll
that
just-
motion?
Is that how we do it?
I think what would work is
Do
if
one
the
by
board
one?
considers the decrease, and then address the decrease for number one, and then address number four, without having to have any mention of number two and number three, because eventually what will happen is, if the decrease is authorized, we will meet with Ms. Taitingfang, inform her of the requirements, and since it's subject to survey, one of the requirements to come into compliance is to perform or to pay for a survey. So, anything related to assessing taxes, usually that's driven by either the tax map or a recorded lease or a recorded map. That will be on the RT, just so that, to provide some.
A clearer motion, okay.
If I may,
So-
Yes,
So I'm trying to figure this out. We have three folks speaking for, actually, three commissioners and Mr. Joey. And I'm actually lost, to be honest with you. There's a lot of discussion to try to figure out a motion.
if I may add, Commissioners, I had a conversation with Taiting Fang, and initially when she requested a reduction of acres from 5 to 2 initially, and today it's still, she still has the 5 acres. And she explained to me that she was glad, you know what, it's unfair that I waited this long and I still had to pay those taxes when this thing should have been done. Why is it taking 4 years? And I had to pay all those taxes. She feels like it's unfair for her that she had to pay all those taxes, since we had opportunity to discuss this matter in prior years, and it was put on hold and pause, and she still, out of her own will, pay the taxes, which she didn't want to pay the taxes from 2021 to 24, but she did. But she's just trying to, with her little budget that she has, try to, request this tax waiver. I just wanted to put a comment on that one there.
Can
for
I
our
also
conversation.
say something? When Glenn first came here, I told him that, with the, Miss Cassim and, Miss Brigade coming to see me, at times, I've asked to be given, an authorization to find a surveyor to survey the place. And they kept, nothing was ever, in response to my asking them for the authorization. I was never given an authorization so that I can go and look for a surveyor, so I can survey what I.
To my knowledge, you don't need an authorization to provide a survey. All you need to do is contact a surveyor and request for a survey in a particular parcel.
no, but
What
here's the
authorization?
Or
point.
here, an authorization is needed. But if I may speak to that, is, again, initially, Mr. Taiting Fong's lease has been, or was classified as a lease with a cloud. If Public Law 37-131 was not passed, today, we will continue with that moratorium of not allowing any lessee to conduct any improvements because of the uncertainty of their lease. If we were to apply the law at that time, we would present it to the board to terminate everything, 2,800 some leases. But given that the 37th legislature had introduced a bill and Governor Leon Guerrero had signed it into law, it provided us the avenue to address those leases with a cloud, with a legal cloud. So I believe during the time that Ms. Taiting Fong had come in, there was sort of a moratorium type thing that was placed, so that no lessee is subject to exhausting any of their personal funds with the uncertainty of what's gonna happen to their lease. That's why today, now, we're proceeding and we're conducting all these compliance inspections, because there is a way forward. It's it's almost like the null and void situation that had occurred with some of the leases within CLTC. Again, there was no avenue to address that, so we didn't issue any type of authorizations for the lessee with a null and void lease to conduct any improvements. So just to speak to what happened within those years.
Also want to add to, of course, the director mentioned that there was a cloud, in the lease, and her late husband applied December 7, 1995, and it's a pre-occupier, and they've been there since the 80s. And they were living and occupying that farm way back, and to date. But they're no longer farming because the husband's now deceased, and this is why she's here today, asking a reduction. So I just want to make note that there's a law that, if you're preoccupied, you cannot evict them from the property. But to give them a lease, they have to wait for their date and time, and that's what we did. We are December. Let's see what the date they are. The December 7, 1995 applicant, and although they've been occupying their property, this is why it was deemed as a lease of a cloud, because the date and time was not when they were issued a lease, but they were preoccupied. I just wanted to note that.
Okay, no.
Mention that.
My question, based on what's being transacted here, is when was the lease formalized? What year?
I believe that 1998.
1998?
Yes.
And at the time of the lease, who was responsible for the property taxes?
Let's see.
Okay.
The late husband.
So, but yet the lessee is asking to not pay for the 5 acres?
They've been paying.
Which is their obligation?
With the obligation, now the circumstances changed, where she's assessed by herself.
It hasn't changed, the circumstance hasn't changed, she's still.
As far as income.
Legal document is 5 acres.
Yeah.
To Mr. Rojas's proposal is, we cannot prorate the tax, but when she does survey it and downsizes the property, that's when the new property tax should kick in for half an acre instead of the 5 acres. So the onus, I'm sorry, Mrs. Technical, but the onus is on you right now.
I understand that, but see, as I said, when I came here, I noticed, presented his death certificate that he's no longer here, and I will pay for all these bad taxes, and I did to the present. And that's why I asked for an authorization. During that time that I presented that, I asked for an authorization to get a surveyor. I never got an answer or, any document. If I had, then I would have done, since that day that I came in, 2020, I'm sorry, when I presented his death certificate, and I would have the place surveyed and given the request of my reduction. I wouldn't be paying for this 5 acres, right?
If you had requested in 2020, the year you're stating that you were inquiring about this,
Yes,
if you had,
if I had
if
been
you
given
had-
the
if you
authorization
had-
to get a
if you had
surveyor.
requested to downsize your property at that point in time and did the actual subdivision for it, then you won't be paying from then on to now, from 5 acres, you would have been only paying on half an
Yes.
acre.
But I never did get any permission or authorization to do that, which I came and I asked.
Was this, I'm sorry, this is Commissioner Cameron. I'm trying to understand, was this 5 years ago?
2020, sir.
about?
2020, and
Yes.
here we are, 2025. This is horrific.
I submitted a death certificate in 2020, and I asked for authorization. I've done all the things that they asked me to do, written, things that,
Ma'am, when you said they, are you talking about the staff of the commission?
yes, sir.
And this is back in 2020.
I think also that, this is Commissioner Resticio speaking, that she did make a request in 2020 as noted in the staff report, but then again, today her request has changed from 2 acres to half an acre. So we would still be here again today, had everything gone the way she wanted back in 2020, if you look at the timeline, from the 2 acres to the half an acre. So I would like to proceed with the motions. I believe that the motion to accept the first request of the decrease of acreage from 5 to half an acre has already been made and accepted and approved. Is that correct? And
Correct.
I would like to proceed with Commissioner Rojas' motion for items number 2 and 4, or item number 4 only.
It was just, well, I think it's better I amend my motion to remove item number 3 as per our discussion. So, Madam Chair, I'd like to amend my motion to address item number 2 and make the decrease subject to the lessee paying for the survey of the property. And also address item number 4, to accept the current building structure, but based only on our lease requirements and not pertaining to any issues with permitting or building code.
I second.
All in favor, say aye.
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 That means 4. 2 seconds.
Thank you.
Did we make any motion for item number 3?
No.
No,
No.
only 1 and 4.
1 and 4?
Oh, number 2 is part of 1.
2 and 4.
It's subject to survey
Oh, okay.
on her
Thank you.
expense.
C, lot 101-22-15, Dedito.
Madam Chair, the only item related, or the only matter related to this item is the validity of the authorization to occupy. I ask that the board consider tabling it until the presence of Attorney Miller. Attorney Miller and myself did meet with Assistant Attorney General Finney, who is the legal counsel for the Guam Environmental Protection Agency. Although I would like Attorney Miller to be present so that he can explain the legal aspects of what may arise. I don't want to misinform anybody.
In light of that, Madam Chair, in regard to item C, or I make a motion to table item C, lot 10122-15, Dedido, subject to discussions with legal counsel.
I second.
All in favor, say aye.
Aye.
Motion carries. New business, board meeting time limit.
Madam Chair, there was a request for the board to consider adjusting the meeting time of our board meetings, either from 12 p.m. to 1 p.m. or anytime 5 p.m. on. However, in your packet, you'll find a copy of the Chapter 75A subsection 75A 102C, which is highlighted. The act does require that the commission shall meet regularly on the third Thursday of every month at 1 p.m. or more often as defined by the chairperson of the commission. Although there was a request, we want to ensure that it's addressed by the board. However, we did provide information related to that and what's required within the act.
Any questions?
No?
As stated in the GCA Real Property, Chapter 25A, CHamoru Land Trust, Commission effective January 1st, 2021. That's Section 75A 102. C, paragraph C. So be it. You need a motion?
Yes, I believe because it's a request, we should honor it and address it with a motion. Whether the board will consider 12 to 1, meeting 12 p.m. to 1 p.m. or 5 p.m. after 5 p.m.
I just want to make a short comment on this. Since we require that the CLTC staff participates in our board meetings, and it's well known that the regular lunchtime for staff is 12 to 1. So I think it would be not to the benefit of the staff to have to take lunch earlier or later. And based on the law, I think we should just comply with it. Now, any extra meetings that may be called by the chair will be at her discretion as to what time the meetings will start. That's my view.
All right, Madam Chair, I'd like to make a motion to continue to follow the item C in Chapter 75A, CHamoru Land Trust Commission effective January 1st, 2021, requiring that the commission meet regularly every Thursday of every month at 1 p.m. or more often as determined by the chairperson of the commission.
I second.
All in favor, say aye.
Aye.
Motion carried.
Can I still make a comment? The only comment I have with regard to new business item A is, it says here, meeting time and limit. It didn't say meeting time, but with regard to meeting time and limit, maybe we can address that by just encouraging all commissioners to pick up their packets as they are announced to be ready for pickup, and to review the packets thoroughly so each commissioner is prepared to participate to help move the meetings along. End of comment.
Madam Chair, the next item is item B, constituent matters. We have present today Ms. Carmen Artero Casperbauer. Just so everybody knows, Ms. Casperbauer was or is part of one of the cohorts for a new Lease award. Ms. Casperbauer and Mr. Casperbauer, if you would like, please come up to the table. Ms. Jessica Dede is the land agent who was handling the processing of Ms. Casperbauer's case, so she'll present Ms. Casperbauer's case. Her situation is a little unique, but nonetheless, she has qualified for the program and all that other great stuff, and she's here today. There's just some other information that may come as a surprise to you, but nonetheless, she's eligible for the program.
Okay, so commissioners, my name is Jessica Dede. I'm a land agent too with the CHamoru Land Trust Commission. So today we have Ms. Carmen Artero Casperbauer, and the request is an agriculture lease award for lot 10129-R10 in the municipality of Dededo. The second request is Ms. Casperbauer would like to lease 14,230 square meters, which she had surveyed. The issue with the square meters is that the commission per 21 GCA chapter 75A subsection 75A 107A leases to eligible beneficiaries, licenses. The commission is authorized to lease to eligible beneficiaries the right to use and occupancy of a tract or tracts of CHamoru Land Trust property within the following acreage limits per each lessee. Number one, not less than 1/4 acre, nor more than ½ acre for subsistence, agriculture, or aquaculture farming. Also, per 21 GCA, chapter 60, subsection 60.112, Ms. Casperbauer is required to obtain legislative approval for the 14,230 square meters for which she is requesting. So Carmen Casperbauer was awarded a ground lease on June 5th, 1997 for lot 7150-4 in the municipality of Jigo, and another ground lease on April 20, 1998 for lot 7150-4-2 in the municipality of Jigo. Both ground leases were then declined on June 4th, 2009. Ms. Casperbauer was then issued a notice of intent to award for lot 10129-R3.
Hold on, you're going a little bit too fast. So you're saying that on items 2 and 4, she was awarded a ground lease, and then on item number 7, is that, it seems like, is it the same property or?
It's two separate.
Yeah, so then she was declined?
She then declined it.
Oh, she declined it?
She declined it
Okay.
for the property that she
Okay, so,
then surveyed.
okay, so the awardee declined. Okay, go
Yes.
ahead.
Okay, so Ms. Casperbauer was then issued a notice of intent to award for lot 10129-R3, now known as 10129-R10, which is located in the municipality of Dededo, which contains an area of not more than 5 acres and is subject to final survey, DLM approval, and recordation of the map. The survey map was finalized on April 14, 2021. No action was taken,
Okay, hold
because
on just a
Mr.
minute. So
Okay.
that lot 10129-R3, that's a new agriculture lot, and what is the square footage on that?
For, that is actually a total of 5 acres.
Okay. Okay, go ahead.
Okay, so no action was taken because Ms. Casperbauer did not obtain legislative approval for the
For the 5?
three-quarter.
Oh,
Okay, let me just, so she was given 5 acres.
Okay.
However, she wanted to give to her other 2 daughters, I believe 1 acre, 1.5 acre, close to 2 acres. And then the remaining would be her acreage, which is 3.5.
Okay,
So that's how her square meters is only 14,230 for her lease award.
okay. I guess what the confusion here is that you're using 2 kinds of measurements. We're talking 14,230 square meters, and then you're converting it to 5 acres. 5 acres is more than 14,230 square meters.
Okay, so I said that Ms.
So-
Casper Bauer was given a notice of intent to award for lot 10129-R3 located in the municipality of Dededo, which contains an area of not more than 5 acres.
Okay, so that's item number 15 you're speaking to. Not more
Well,
than,
that's the chronology,
okay.
okay, but,
Yes, I'm trying, that's why I'm saying I'm trying to follow.
okay,
Okay, so not more than 5 acres.
right.
May I say something?
Yeah,
Can I say something?
yes.
Recently, somebody from this office told us that a 40-foot easement was taken from the 5 acres because that's required to get access to the school. Or you have to have an easement along the property, because on the other side of the property is the fuel line by Route 3. And so 40-foot easement, a road that they used to go up to the school was taken off, so that reduced it down to 3 something. That's the way we understood it.
We'll-
Actually, when it was surveyed,
We'll verify that, Senator Casper Bauer.
You folks told me that, your office told us that.
We'll verify it, we'll ensure that there's recorded maps that provide,
Well, they're using the 40 foot of the property then.
we'll
Driving the buses up, I think the gentleman there told us that.
we'll verify, we'll verify.
Commissioner Respeto,
Yeah.
if you look on number 12, item 12 on the chronology,
Okay.
so it says here that on August 14, 2009, there was a request approval for preliminary sketch for 3 lots.
Okay,
So that is how Ms. Casper Bauer ended up with the 14,230.
okay. That's 3.5 acres, okay.
If I
Yes.
could provide
That's
just-
where you're saying that the other 2 lots were for her children.
For her 2 daughters,
Right.
yes. So that's how the survey was done. 3.5 for Ms. Casper Bauer, and then the other 2 for her.
Which equals the 5 acres?
Yes.
On item 15, okay.
So who is who's the applicant?
Ms. Casper Bauer,
And this is for agricultural,
yes.
but yet,
She also submitted her farm plan for the 3.5 acres.
well, my following question was, there are 2 children that are gonna be included in the 5 acres?
So if I may, initially, Ms. Casper Bauer was given a lease in Gigo. She declined that to move to a lot in Dededo, which she declined again to move to another lot in Dededo,
Okay,
which would contain not more than 5 acres. However, Ms. Casper Bauer also has daughters who are applicants. So instead of obtaining the whole 5, and correct me if I'm wrong, Mr. Casper Bauer, they decided, okay, we'll divvy it up. 3 acres to Mrs. Casper Bauer, 2 to 3 acres, and the rest will be divided amongst her daughter Karen, and I forget. the
because they
other-
are also applicants.
Yeah, they're also applicants, and they're within the same date and time of each other.
That's what I want
And
to be
Teresa.
clear. Okay.
So, today, the reason why Ms. Casper Bauer is here is because based on the processing or the commencement of the lease award, when Ms. Casper Bauer declined the first 2 leases, her application was just that, at the application stage. She's here today, also because, she's surveyed her property, which is kind of unique, right?
Which property?
The
one
Dededo,
in
the
Okay.
3-acre property,
The 10129-R3?
R10 or R9 now?
Well, it's known now as R10.
R10. After the survey, there was
became
no more,
R10.
yeah,
Yes.
no more remainder, it became a 10-10. So what it is today is that because the act clearly defines anything from a half acre and below is considered subsistence, anything greater is considered commercial. Now today, based on the chapter 16, I think public law 33-64, if I'm not mistaken, anything over the half acre requires legislative approval. So today the board can approve, however, that approval will not come to fruition until the legislature approves. Now what happens there, this is the first case that we are dealing with, that if the board should approve the 3 acres that we're gonna send to the legislature for their approval. What their process is, I don't know. Like I said, this is gonna be the first time we do something like this. However, it's not to say that the board cannot approve the issuance of a 3 acre, but the requirement is the legislature still needs to approve.
So the 5 acres, so what we're saying is within the 5 acres, we're taking care of 3 applicants.
Based on the actions that had taken place, that's how it is.
Yeah, so that's what, so that's on item number 15, the 5 acres is to take care of 3 applicants. 3 acres for Mrs. Kasper-Bauer and then the acre and whatever
For
for
the
the other
daughters,
2
yeah.
daughters, okay.
Today, we are only speaking to the 3 acres for Mrs. Kasper-Bauer.
Okay, so we should
Which is
make corrections in this
14,000.
presentation.
But then right here in the request, it's requesting to lease 14,230 square meters, which is 3.5 acres.
Acres, yeah. That's
Give or
what,
take.
that's what he's saying, just only address the 3 acres.
That's what is
Yeah.
put as the
Yes.
request.
So the R3 is just the 3 acres?
The R3
Is now
is
known as
now
R10.
It's R10.
Okay.
and that's just a 3.5
Okay,
acres.
okay, got it, okay.
Okay,
I think throughout the process when, you know, not messy, but a lot of things had occurred. But to clarify things, the lot that we are discussing today is the R10, which is the 3 acres for Ms. Kasper-Bauer.
Okay.
Which is this one.
If you're not familiar with the area, it
How long
might,
since this request was made?
So it was done in, so it was served, it was given to her, an NOIA was given in 2009. However, I don't, there was nothing saying,
There are many
What
issues that
happened?
occurred. One for sure is the surveying services that Ms. Kasper-Bauer had obtained. I do recall myself and Mr. Haddock meeting with Mr. and Mrs. Kasper-Bauer and their daughters at one point. And then when it was going through the process, the check print process, the map check print process, that is contingent on the response time of the surveyors. So if there's a correction that needs to be made, they don't come for a long time, it sits there and follow-ups are made. So one of the concerns that was, or one of the issues that did delay is the response time of the surveyor that was hired, in addition to all these other laws that were passed. But however, today, there is a way to address it. And again, like I said, if the board decides to approve Ms. Kasper-Bauer for the 3.5 acres that she had surveyed and she had paid for the survey, that is now known as lot 101
Dash 10.
29-R10 or -10, the board is still able to approve such an award, although the
Subject to the legislative approval.
approval.
Now, this is going to be considered a commercial lease?
We don't know, as I mentioned, when it gets to the legislature, how they may decide or whatever discussions may occur, we don't know. But just for the boards, for disclosure to the board, we will be bringing up leases that are over half an acre that does read rate to be determined at a later date. So if they're not being charged $1 a year, we have to resolve that. I don't know if Ms. Kasper-Bauer's lease rate will be anything different from $1. I'm not too sure.
What does our mandate tell us we need to do if it's going to be a commercial?
There's a process. we can go over that. I believe they're gonna be required to get two appraisals. We take the average of the appraisals. The board will decide what the rate will be per annum, and all that other great stuff.
Have appraisals been conducted?
No,
Is the intention of your farm for sustenance for your family and neighbors, or is it for the purpose of?
I'm sorry, I forgot to bring my hearing aid, so can you
That's
speak a little louder?
Is the intention of the planned farm for the sustenance of your family, or is it for the purpose of reselling your farm goods?
No, because my family used to own, all of Anderson Air Force Base and all of, now they call Camp Bluffs. So we lost practically, their Terrell family were made landless, so I thought, my house is near Finnegarden Elementary School. So the idea of leasing that next to Finnegarden is to try to plant indigenous plants that are becoming extinct, to try to save them and promulgate them. And then maybe some seedling is the school nearby, the kindergarten, first grade, and second grade, they can come for learning about the plants of Guam and the indigenous plants of Guam. And maybe they can get some seedling on Father's Day, Mother's Day, and, so that we wanted to promote the plants of Guam. That was one of my main intentions, not really for me to be doing it for business.
But since then it changed, so now
Yeah.
we want to plant the trees to grow the fruit and things like that.
Yeah, and then
And our house is right across the street. And initially it was a little bit bigger piece. But with all the delay here, since we had it surveyed, as we were told to do all those years ago already, and thought that it was all ready. Meanwhile, all the agencies are putting antennas and stuff in there, so that's why it's reducing down. So right now, there's a little strip of it along Artero Drive and the fuel line, and then Chellen Kasperbauer going up to the school. So it's right in there, a little strip, and then there's a big water well and all that stuff. And then there's other tennis going in there. So as those tennis go in there, this is being reduced and reduced and reduced. So
So the reason I asked that question is to determine what kind of lease, if it's a commercial type lease for commercial farming, or if it's for family sustenance, in which case, couldn't we just do an agricultural lease?
Can I have?
that's what we thought it was being.
Let Joey talk.
My name is Joey Cruz. I'm actually their granddaughter's husband. In doing, I guess, the farm plan, to answer your question, Commissioner.
Well,
it's
wait
for
a
both.
minute, just a second. Because this has been going on a long time, and we're almost 90 years old now. She recently came in and listed his wife, our granddaughter, to acquire it now, which is now possible. But that would be, when she dies, it will become his wife's property.
So the reason I asked that question is so we can circumvent the legislative process, right? If it's just for agriculture, do we still have to go to the legislature? Or if
the
it's just for
size
their
exceeds
sustenance?
half-acre subsistence farming, it has to go to the
What,
legislature.
even if it's for their own personal?
Yes, ma'am.
Okay,
But to answer your question, it is for both,
Okay.
both family and.
okay. So at this point, it doesn't matter if it's for commercial or for sustenance, it still needs to go to the legislature. That's what okay.
And will the legislature determine if it's,
Like I said, this is our first case to forward to the legislature for this concern in regards to their approval for the area size. I have no idea of what could happen. They may deem it for commercial use, they may attach or decide the rate, they may not. they may not act on it. I'm not too sure.
What does our rules say with regard to the crafting of the lease? Is it the legislature that crafts the lease and
No.
sets the rate, or it's the commission?
It's the commission, we have a standard lease already, a template. However, when, I believe it was the 3364 or 30, it's in the 33rd legislature, 33-78. So it reads to an act to amend subsection 60-112 of Article 1 of Chapter 60, Title 21. It reads, subsection 60-112, legislative approval required. Notwithstanding any other provisions of law, government-owned real property shall not be sold, leased, subleased, exchanged, or otherwise transferred without the prior approval of the legislature by duly enacted legislation, which specifically authorizes a particular sale, lease, exchange, or transfer, and includes the real property description of the government-owned real property with particularity, and the Department of Land Management recorded map showing the alienated parcel and the remaining parcel of the original lot. This section shall not apply to the Land for the Landless program or residential leases, subsistence agriculture leases, and subsistence aquaculture leases by the Chamorro Land Trust Commission pursuant to its rules and regulations, but shall apply to any transfer to the federal government or any agent of the federal government of land owned in the name of the government of Guam, including but not limited to autonomous agencies, public corporations, the Chamorro Land Trust Commission, and the Guam Ancestral Lands Commission. So based on prior legal guidance, anything over half an acre would require the legislature to approve.
That's the commercial lease.
Because the acre size exceeds the categorization of subsistence farm.
Okay, so this is being targeted right now as a commercial lease based on our mandates, correct?
It could be perceived like that.
And is that something that can or would be determined by the legislature?
Like I said, I'm not sure,
Okay.
because
Okay.
this is our first.
Now, with that being said, I think it'd be more to our advantage or to our benefit to request that the appraisals be done before we submit it to the legislature, so we have an idea of what this lease would entail.
Okay.
I think that is good.
He's recommending that, Commissioner Garrido's recommending that appraisals be conducted prior to referring it to the legislature for approval. Like I said, this is gonna be our first case to refer to the legislature. I don't know whether appraisals will be required, I'm not sure.
But it's in our mandate that we have to, there has to be an appraisal.
There's,
For
when
commercial.
it speaks for commercial uses, two appraisals are required.
It's required anyway.
We're not using it for commercial.
We're not using it for commercial.
That's not the intent. It's right across from our house. We want to plant fruit trees and things.
So the
And,
issue here is,
And we're both former senators, so who knows the legislature? We know about the legislature.
You know,
We're the only living husband-wife former senators.
both Mr. and Mrs. Casper-Bauer, it's a good thing for you to plant those native plants, because what has happened up in the north, where Captain or General Ben Bloss camp had destroyed a lot of our
Sure did.
native plants. And
Sure did.
yeah, and I can understand where you stand when it comes to native plants.
Yeah. Pero I don't know, we can never grow padang anymore because Blas is where the fadang trees are prolific. And it's the sustenance of the CHamoru people during the war, you know? And I don't know, I was hoping that we can find some fadang, and if we get the CHamoru land trust, try to plant them to see if they'll grow, and some other, you know, native plants that are becoming extinct.
I know it's off subject, but if it wasn't for her family, this would be Japan. They hid the only American, George Tweed, who turned Guam back to America from the Japanese. And this, all that land was taken from the family, and this is the only piece we're trying to keep going.
So if there's no further discussion, I'd like to make a motion. Any further discussion? I'd like to make a motion to accept the request as presented to grant Mrs. Casper-Bauer's request to lease the 14,230 square meters that she has already surveyed, and to proceed with the agricultural lease award for lot 10129-R10, and the legislative process and the normal processes shall follow.
A second.
All in favor, say aye.
Aye.
Thank you, Mr. and Mrs. Casper-Bauer. We will be reaching out to you. We'll prepare the papers and the process, and we'll share it with you.
And then our
Good-
daughter,
good
Karen,
luck.
I think is on the agenda.
Yes, but
She's off island.
we're gonna request to table her because of she's off. Okay?
Okay.
See there, our daughter Karen is next, and then Teresa. But Karen's off island.
Thank you, Senator Sam.
Thank you.
Susunod mo sa ito sa akin.
Algo más. Kaya sinyaman mo
Okay, got it.
na ang tiyo mo. Thank you.
Thank you, Senator.
Do I have to sign it?
Please, yes,
Huh?
please, yes. Madam Chair, the next item, number 2, B2.
Break.
Break time. Time out.
Okay.
Question, this is Commissioner Cameron.
Yes?
Yes, I'm noticing that we have number 2, number 3, and then termination applications 1 through 15. Is that, 1 through 15, is that another 3 hours?
No, it's,
It's easier.
it should be quick.
Okay. Only because I'm right now taking, I'm taking now annual leave. I cannot be paid by the federal government beyond 1. I'm taking my lunch hour at 1 to 2, and so anything after 2, I'm actually taking leave. I'm losing money. So I need to be upfront and honest with you that anything beyond my lunch hour, the feds pay my salary. So if I'm gonna do something outside of the federal government, I have to take leave. So that was my concern when we were trying to talk about our meetings. I would probably have to resign.
Don't resign right now. We're gonna take a 5-minute recess.
Take a break first, sir.
I need to make a motion for a 5-minute recess. We shall reconvene at what time?
10 minutes better?
10
In case-
No, 5 minutes,
Okay.
because Commissioner
Lunchtime.
Cameron
No.
is pressed for time.
Aye.
10 mi- oh.
Anyone second?
Second.
Okay. recorded, the recording, or?
Yeah, the audio part,
And we can move
it
into D.
keeps saying not connected. Let me just get a hold of Joanne.
Commissioner Cameron has raised his hand.
Are we,
We're not recording yet, right?
I've been on this now. Just now.
Okay.
Just the air is back, if we are, your mute is off.
What device is that?
Hello, I'm back.
There's technical
Hey Carlos, it's
difficulties.
Karen, how are you in
Oh, there.
Arizona?
Good, it's 1 a.m. your time,
Yeah, now almost 2. Just, if the board is back, their microphone is off, so I don't know if they've reconvened.
huh? It's 11 o'clock my time too.
Hey, Jay, past their bedtimes.
I'm gonna ask, I don't know if they can hear me, I'm gonna ask if I can.
We're
I'm
back
already down
on.
in number H.
We're still on
If I
mute.
Yeah.
And
I'm-
then I can just be jumped up, if I could,
You're
if I could.
still on mute.
Yeah, I'm next to Megan, and I'm gonna, I have just a very short request.
are we back on?
Okay,
Thanks, I promise, not even a minute.
no, it's on the agenda, don't worry.
You're on mute.
Take off the
There,
mute.
you
Yeah,
go. Take off your
there you
mute.
go.
There you go.
Can you hear us now?
Can you hear us?
Yes, I can hear you, thank you.
Okay, because she's there, I guess we don't have to table her.
Okay.
So, after, Mrs. Casper,
Madam Chair, you
Number
can
2.
call the meeting back to session.
Oh, yes. We're back in session.
3:42.
3:42.
Thank you. Madam Chair, the next item on the agenda is Ms. Karen Casper-Bauer Paris. Initially, we thought she requested to be tabled, but I believe she's present on the Google Meet. Ms. Paris, are you there?
Dr. Day, yes, I am, and I just wanted to thank the board for putting me on the agenda, and as Acting Director George Cruz mentioned, my request is to be tabled till August, since I am currently off island and would rather be physically present at the meeting. So I hope the board will entertain my request. And if I could be put on old business number 1, maybe, please.
Definitely.
Madam Chair, I'd like to make a motion to table, as requested by, Karen Casper Paris.
second?
All in favor, say
Aye.
aye.
Hi.
Buenas, thank you, and have a good afternoon for Cutlass, have a good evening for myself, it's already almost 2 in the morning. So, San Jose, and thank you very much for all your hard work and time.
Thank
You're
you.
Thank you as well.
Okay, next is Nanette Marie Paloma.
Okay, Madam Chair, Commissioners, the next constituent here is Lynette Marie Palomo, and she's part of the 1995 list pending for lease issuance. The request today is to remove residential application from the waiting list. Based on 18 Guard Chapter 6A, subsection 6A110, application for leases reached an island-wide waiting list. An applicant who is awarded a lot shall be able to decline 2 different villages. After declining the third award, an applicant shall be removed from the waiting list. So this is a case where an applicant was issued 3 leases award and declined all 3 of them. And if you can look at the chronology on items 7, 8, and 9. On item 7, on May 16, 2002, Ms. Palomo declined a municipality award on lot 3, block 20, tract 9210. And then on 12/13/2005, second decline municipality award is on lot 2, block 1021. And the third decline is on lot 5401-1, Manila. So based on the, yeah, okay, and Jigo. So based on the law that I just mentioned, 68110, if an applicant is awarded 3 lots in different villages and they decline it, their name shall be removed from the list. So this is the case where she declined.
She declined 3.
3, and through discussions with her, the reason why she declined it is because her mom has a lease already, and she's wants to take over her mom's lease, so that.
So there's no need for this lease.
There is no need for this lease, right, correct. So that's her
So she's
her
not
statement.
contesting this at all?
She's not contesting with it at all, but I had a discussion with her last week. She came over to our office, and we're in the process of getting her qualified in the new law, chapter 75A, so that she meet the eligibility as a eligible applicant. And once that's determined that she qualifies, and her mother too, we can continue with the transfer of lease. By law, if you hold a lease over 7 years, you can transfer your lease rights to anybody. It doesn't have to be a non-relative. So the mother meets the requirement.
So, Madam Chair, I'd like to motion to remove applicant Nanette Marie Palomo from the application waiting list.
I second motion.
All in favor, say aye.
I,
Motion carried.
Madam Chair, I'd like to make a motion
Yes.
with regard to new item C, termination of application, to accept the termination of applications as all stated from items number 1 through 15.
Commissioner Respicio, if I may.
Yes.
May I request to remove number 11, Ms. Ruby Jean Quintanilla. The reason why for the request is that Ms. Quintanilla is on this listing due to a transfer of application rights by a living applicant. Before we can proceed procedurally to be done correctly, we need to revert it back to the original applicant, then proceed with the termination. So if I may, request to remove number 11, Ms. Robbie Jean Quintanilla.
I'd like to amend my motion to, under new business, under letter C, termination of application for persons listed as number 1 through 10, and persons listed as number 12 to 15.
Second.
All in favor, say aye.
Aye.
Now we go into bill number 6-3.
Madam Chair,
Yes.
may I make a suggestion, please? We have a representative here from the Guam International Golf Association with Golf. And these others have no representation here. So could we fast track it and we'll hear the golf course?
Letter H first. Do we
Letter
need a
H
motion for
first.
that?
Letter H.
Yes.
Madam Chair, I make a motion to hear letter H in new business before items D, E, F, G, and I.
All in favor, say aye.
Aye.
President is Mr. Yo Hing, General Manager of Guam International Country Club, and also online is Mr. Carlos Camacho.
Okay, then, okay.
Today.
Mr. Yo Hing.
You already, do you want me to speak?
Yes, please.
Okay, Commissioner Chairwoman Verdalio, Commissioners Garrido, Commissioner Respicio, Commissioner Ross, Commissioner Cameron, and Acting Director Joey Cruz. Thank you very much for allowing us to jump on the schedule. I too, I'm in Arizona, it's about almost 11 o'clock at night, but I would have stayed as long as I could if it's in the agenda, but thank you for the opportunity. Before we speak, I wanted to give a little history and a chronology of the time frame of this endeavor we're doing since 2023. In August 2023, for the new commissioners, Cameron, Commissioner Ross and February, Respicio, I just want to let you know that since August 2023, we came in to CHamoru Land Trust when there was, at that time, Chairwoman Verdalio and Earl, Commissioner Garrido and others at that time, when we were impacted from the COVID-19 and all that, and try to figure out how we can diversify our economic use. And before that time, when we presented our alternative solution, we had made a payment plan on our arrears that we owed because of the lack of economic activity during those time frames when we were closed during the COVID time and all that. My client, the GSCC golf course, did not avail himself from the SBA because the SBA loans and all those programs that were available was available for U.S. corporations and companies. Unfortunately, my client is a Japanese-owned corporation, so we was able to be availed in those programs. That's the reason in the early time frame, we requested in the previous board, what can we do to either defer it or pay it, and we were granted a deferment, and that's what we've been doing since that point forward. At that point, it was mentioned, just a little history, but Commissioner Garrido had asked that they'll give us a window of opportunity if we were late in any of our deferment or not paying it, then the commission will act on what needs to be done to take over or, repeal the lease that if we are not complying and paying it. They gave us the opportunity to make sure we make the payment. We've been doing that. And that's when in August, again, in 2023, we submitted a proposal to diversify the economic use. Of course, because it will be subject to legislative approval, because we were going to extend the request of our lease for 15 more years. Our existing lease was from 2014 and matures in 2039. So we needed an extension for one of the economic use what we were doing. Now, on February 16, 2024, almost in between 23 to that, it was 6-7 months. We've been going back and forth with the commission. It's in your public record, and we did everything publicly to all you publicized Thursday meetings. And on February, before that, on February 5th, I'm sorry, we had a bill called 179-37 to the legislature. We had a public hearing on that at the Guam legislature. Then on February 24th, February 15th, 2024, 10 days after, a resolution by this board supported 17937. But what had happened when it was brought up at the legislative session, there was a technical error in the resolution. Nobody's fault, you guys, as you guys can see, you guys spend 8-9 hours at a time. There was a technical error when the resolution adopted the wrong bill number, number one. And number two, the resolution identified the wrong lot number, but luckily the recording number identified the lot correctly. So on April 2024, the board reconvened, and it was Commissioner Dorito that made the motion to correct the adoption of the bill. And from that time, a resolution was supposed to be submitted down to the legislature. And I know with you guys, short staff, Joey's staff, a resolution with the new adoption after April 24, to our knowledge, I may be wrong, was never submitted to the legislature, or maybe it did, it just never made it to the parties to be at the legislative body. So after April, it stayed down at the legislature. It never made it through the final 99-yard line to either get it voted up or down. The legislature then ended its 37th legislative career on the November timeframe of 2024. So that Bill 179 died. It never made it through the proper process. But what we've learned in that process was a lot of ask through the body of the legislature. And the ask was, why are we using the same rental rate to carry the next 15 years from 2014? That was the first concern that we identified during that legislative floor debate in that early part. Number two, why wasn't there any safeguards in regards to in the event they don't win, my client does not win the RFP bid for GPA, any safeguards on putting back the property back to a golf course. So if you look at Bill 135-38, it incorporated those concerns that was brought up in the legislative debate and session. And number one, it incorporated the ask. So if you look at it, the original bill sets from 7 to 9 million. This new bill set 9 million, and the 15-year extension would be appraised by CHamoru board choosing your own MAI appraiser to appraise the extended lease so that you can combine the existing lease plus the extended lease to find out your net present value and get the final number to be incorporated into the final lease if you guys desire. That's number one. Number two, the bill also incorporated in the event the client does not win the RFP, that the bill, the solar farm approval will be null and voided, and it'll be back to a golf course, and the existing client, GICC, will repurpose or rehabilitate the golf course back to its use. So there is a safety net in that case that happened. Finally, the bill also incorporated the use at the board's discretion, not legislative discretion, at the board's discretion to provide the 9 million into the 3 asset resources that the board has in its inventory for decades. One of them, as you saw in the bill, is on one section, I forget what section, it's my late night, but in the 9 million distribution, they were gonna allocate $7 million to a project in Jigo. As we all know, as Project 166. This was done in 2013 by this body, your CHamoru Land Trust body, that went out and got the Land Use Commission approval, the rezoning approval, the master plan of 166 lot approval, and that is fronting Marine Drive across the Jigo Mayor's office. That never made it through because it lacked the infrastructure resources and financial resources at that time in 2013. 13 years later, there's an opportunity. Yes, you guys got, as I've been watching the news, you guys got the first group of 9 million that's been appropriated through the surplus funds by the 37th legislature. And if granted, you would have this additional 9 million or more, depending on the MAI appraiser. Once they appraise the extended lease plus the existing lease formula. And this bill, at the board discretion, will allocate $7 million to that particular property. So it is legislatively appointed for that property at the board's discretion. And it's giving $1 million to a southern project called Project 319 in Palagachao. That's the one that you guys have already got over 211 leases. The families have not yet moved in because they don't have access to the water or power. That one is not on top of an aquifer, so the reason why it was only allocated 1 million. So there's no sewer needed in that, so you don't need to worry about the aquifer sitting atop like the northern waterlands. Third, there is giving a $1 million allocation to the what was asked from the previous board is the clubhouse for your office space. Now, the clubhouse is 36,000 square feet, more than you need. In the previous bill, it was asked by the previous board, which Mr. Herrera is not there at this time now, but excuse me. It was asked if the 3 housing and land management agency can be housed there, and in this bill now, it's at the board's discretion if you guys want to invite those 2 agencies. But looking at the budget bill, if CHamoru Land Trust relocates there, the other economic benefit they'll have is saving 120-some thousand a year on your annual rent, because this building will be yours, and there will be $1 million of renovation. And this building, if you estimate the cost, and you can get that appraised if you want, this is just our estimated value. It's anywhere from $7 to $8 million if you're going to build a new building. So the building, the 5 acres, is the ask from the previous board. And the ask was to also incorporate land management and ancestral lands commission. But in this bill, it's going to be the board's discretion now. It won't be legislatively mandated, it'll be up to the board discretion. Now, there is another section of this bill. Maybe it's a blessing that we got delayed and not moved in the December 2024 arena. As you know, Guam, and I know Joey's been there in the meetings. I've been in every meeting also on the GURA's CDBG DR, and that is the Community Development Block Grant Disaster Relief Program. In that program, we, as the bill cited, the CFR, Code of Federal Regulation 570.02, you guys qualify to request for infrastructure financial grant requests. Now, to make it very clear, and Joey may know this too, that the allocation amount is only 120 million, and we're asking 40, the bill's asking 45. It's only asked. It doesn't hurt to ask, because at the end of the day, we don't know who else is gonna apply. And if CHamoru Land Trust applies, and if you've been to every of their town hall meetings, they have what they call the economic multiplier. It's not a match. I want to make it very clear, it's not a match. If they're showing any other source of revenue for infrastructure use, and you use that as part of your application process, based on my granting experience, I will assume, I'm hoping, that your sister agency, which is the same administrative body in this government, your executive branch, may not give you 45, but may give you 20, and may give you 15. But that's to show that you got that type of money, supported by the legislative branch, and the board's discretion when you apply under the CPG grant. That is gonna be open in January. As you guys all know, they just completed their final action plan on June 2nd, and they're submitting that to HUD for final approval. And as you all know, they gave stuff, but that's the chronology in history. And we hope that we can get your continued support as the previous board did. And we put more teeth into this bill to give it a little bit more flexibility, more protection, and give the opportunity to get you guys to hire your own third-party appraiser to reconfirm the values. I hope it's not too much information, but that's the chronology. Thank you for letting me explain that. If there's any question I can help answer, please.
Mr. Yohe, would you like to add to Mr. Carlos's statement? Okay.
Anything from the new members?
Mr. Camacho, can I ask how we derive the, and you may have covered this, but the $9 million?
Yeah, you're asking me how we came up with that value?
Right, the net present value.
Okay, I wanted, again, in the history, the original bill 179-37 mentioned a framework from $7 to $9 million. And how we came about that is we took the present rental calculation from 2014 to 2039, and we extended that the same rental value with a 10% or 12% escalation clause up to 2055. And then we hired a third-party appraisal, MAI appraiser. For the record, we don't have that now, but we can give you that copy if you want. We hired Cornerstone Valuation, which I think there's only 3 commercial appraisers we want that are MIA certified, so we can solidify a value between 7 to 9. When we got that value, and when we used 179-37 in the legislative process, yes, we were criticized, and for all due respect, we were criticized that we were using a value from 2014 and carrying it over after 2039. So that's why, when the opportunity came to open Bill 135-38, the opportunity was now to get the value up to the max of 9 million, but get the additional value combined when you guys hire your own MAI appraiser to recertify the new extended lease on today's 2000, if that lease, you guys can ask for 2026 or whatever that time frame would be today, not 2014. But the existing lease we got is already established by contract. We're gonna use that, but we will use the new established lease rate on the next 15 years, combined A plus B, and hopefully we can negotiate something that's palatable for both parties. So that's how we came about it, and the old figure from when it was 7 to 9. Then now this one is a minimum of 9 at the basis, with the extended lease to be appraised with you guys' own third-party MIA, whoever you guys choose. I don't think you guys will choose Cornerstone because we use them already and there may be a conflict. I don't know, I'm not a legal person. You can ask your legal advisor, the attorney, Mr. Miller, for that.
Would it be possible for us to get a copy of that, the documentation you have for us to review?
Yeah, that's available. We have that, and we can provide that, what we use on, the 179-37, lease analysis on our net present value. We can provide that, yes. to, your administrator, Joey Cruz. Maybe Yohei, you probably have that in your file in your office. Maybe you can provide that to Joey, please. I appreciate that, Yohei.
Yes, I will.
So somewhere in this bill, does it say that the CLTC will pay for the appraisal that you mentioned?
I don't know, there is I think I've been hearing, I've been watching all your hearings on the commercial side, it's the commercial tenant that pays for it.
Yes, okay.
You gotta get to appraisal, but I don't know. I don't, if that bill says that, maybe you guys can make a recommendation to follow the statutory rules.
Yeah.
Who pays for the appraisal?
Only because I thought that I heard that you said CLTC can get an appraisal, so when you're saying the CLTC.
Oh, no,
Yeah.
I was saying that, in the 13538, CLTC can hire their own appraiser.
Okay,
That way it's independent, but if, to pay it, if your statutory rules say, like I just heard you stating it to a previous, client earlier, that they have to pay their own appraisal or do
Correct.
appraisal.
Okay.
But, you guys can choose the appraisal and then maybe we can pay that,
okay,
if that's what the statute says.
yes.
But you guys have to choose it, that way there's an arm's length, conflict there, so we don't choose it, you guys choose the appraiser. Other than Valorstone, because they already did it for us. Unless you guys are okay with their appraisal, but that was last year's appraisal.
So what I also.
And that was based on the continuing, value from 2014 forward, not the new one on the extended one on this new bill.
So what I noticed on the first page of the bill is that the bill is asking the escalation of lease for the additional 15 years follows the prior escalation of 10% every 5 years. However, normally when the purpose of the lease changes from the original lease agreement, the actual lease from the time that it starts for the new lease agreement is normally reassessed based on the purpose of the lease. So I think that to assume that the lease rate will remain the same, we shouldn't make that assumption.
No,
For the extension, for the
it
additional
clear.
15 years.
The lease rate from 214 to 239 is already established by contract. The lease rate from 2040 up to 2055 would be based on your new appraised value that comes in. Then there is an escalation clause, I think, if not mistaken, I don't have it in front of me. What we used to pay 10% every 5 years would be 12% every 5 years. Is that clear? I hope
Okay,
that's clear.
yeah, no, I got it, okay, so from 2039, it will, the lease rate will be determined based on the new evaluation. I wanna make
That's
that
correct.
clear, okay.
That's correct.
Madam Chair, if I may. Mr. Camacho, you mentioned that some details of calculating the net present value, which you mentioned the existing monthly rate and then the total lease term, which is 30 years. What's your discounted rate or your desired rate of return that was used in the NPV calculation?
I don't have that in front of me, but if we give you the copy of what Board of Commissioner Rojas asked, you guys will have what was used from our third-party MAI appraiser. If you recall, when we first started this, we had a 10-page PowerPoint presentation that we submitted when it was prior to the new commissioners being there. We showed the different categories of different net present value rate from and that's why we had the value from 7 to 9. And that's why the bill, if you guys, I don't know, Mr. Commissioner Burrito or Chairwoman Burdell remembers that, we showed a schedule from a certain point to a certain point, and it ranged from 7 to 9 when we did that presentation a year ago. But more valid would be the MAI appraisal that we use through Cornerstone that you guys can use as a reference. So, Acting Director Joey, when you get that tomorrow, hopefully Yohei will give you, then you'll see the rate we use. That doesn't mean that's the rate you guys can use. When you guys hire your appraiser, they'll use whatever the current rate, because that was the rate we used last year.
Okay.
The current rate today may be different. That I don't know, when you hire your third-party MAI appraiser. But, you know, subject to us paying that, whoever you guys hire. I hope that clarifies your question, Joe.
One more question is, you mentioned, the rate of the existing up to 2039 January, plus the rate of the new appraised from 2039 to 2055. Now, in the law, it says it shall not be less than, or the bill, it says it shall not be less than 9 million. So are you gonna take the appraisal rate of the existing and then the appraisal rate of the extended? And it shouldn't
No,
exceed 9?
I think if you look at that 9 million, if you guys want us to recalculate that based on the existing contract we have, you guys can get that reappraised and reconfirm if it's 9 million based on that. That's what we came up with, but if you guys want to double check the historical 2014 to 2039 values and get that plus a new one, that'll be you guys' commissioner's call. We came up with that value based on our third-party appraisal on the 014 to 039 up to 2005 with that same scheduled events.
Madam Chair, if I may, we just did our own internal assessment of the bill. And if I may, can I share it with the commissioners? The intention of Bill 135-38 is to amend the CLTC lease agreement with the Guam International Country Club. The bill proposes that within 30 days, if the bill is enacted into law, the legislature is authorizing, approves, and directs CLTC to make specific amendments to the lease agreement between CLTC and GICC. In summary, there are many amendments that some may consider a benefit, like the acceleration of the rent payment due, the use of the clubhouse and 5 acres surrounding the clubhouse, and the opportunity to leveraging the accelerated rent payments for CDBG DR funds. However, there are some questions that we hope the board considers during this whole process. One is, are the commissioners willing to relinquish their authority in determining the annual lease rate or the total value rate of the lease to a licensed appraiser? In the bill, the licensed appraiser will determine what the net present value is, and it should not be less than 9 million. However, in the CHamoru Land Trust Commercial Rules and Regulations, subsection 75-122 of Chapter 75A, Title 21 GCA, the board is restricted from charging less than 10%, can charge no less than 10% of the fair market value. The next item, or the next question to be considered is, how much funds is needed to renovate the clubhouse to meet the needs of CLTC, and where will the funds come from? Will we use part of that accelerated rent payment to pay for the renovations, or not, right? And then the next item is, as of today, and Mr. Camacho is correct, there was a payment arrangement that was approved, and GICC has been complying with their payment arrangement. But as of today, GICC's unaudited arrears is $324,575.92, which leads to my question. Should GICC fulfill its obligations with its current lease in relation to pass-through rent before considering amending the use of the property or not? I do know that in the bill, it does say that within 30 days, if generation of solar power is approved, they will fulfill or pay in full or pay the amount of arrears. However, my question again is, should we entertain any types of amendments to any lease, given that there's still an arrears of 300-some thousand? So I'll Mr. Yoel, I'll give you a copy.
That's a lot.
Yeah, and based.
Joey, real quick, thank you for that description, but can you explain to the new board members how much was the arrears when we started the payment plan? Because to show good faith, I think the arrears was, Joey, can you clarify that? It's 700,000 or something?
It was, so the payment arrangement plan was approved in 2023. GICC is required to pay in full their arrears by January 2026. given that the arrears started at 900 some thousand, yes, they paid it down. But if we look at past history, GICC pays about 44,000 some dollars a month, which is for the current and the arrears. However, there's 7 more months at 26,000. It's not gonna fulfill, they're not gonna be able to pay in full the arrears and continue to pay the monthly payment. If they're gonna pay by January 2026, they have to pay a little over $72,000.
So what you're saying is they have not been good on their commitment to pay.
No, they're,
If you look at the bill, there's, I forget which section, I wish I had it in front of me. It said, once the bill passes, that the arrears will be fully paid, not when we sign a PPA. Once the bill passes, we will pay
within 30 days or something like that.
Please clarify that in the bill, please.
Okay, if that's what it says, I stand corrected, if the bill is passed within, I believe, 30 days. But nonetheless, if we're focused today on the payment arrangement that was approved in 2023, GICC is gonna have to pay a little over $72,000 a month to fulfill that agreement.
To meet their 2026 deadline.
Yes.
Is it because they have not
No, no.
fulfilled?
They've been complying with the payment
Okay.
arrangement, correct. Which is to pay the current month and then the excess to the arrears.
Okay, so they will be in, I mean, if we look at it today,
If they continue to pay $44,438.56 from today till January, they will not,
so they have to accelerate.
yes,
They have to accelerate their.
that to increase.
So I guess that's the number one thing is GICC able to do that? Should the bill pass, are they able to accelerate their payment?
Yes.
Yes? Okay. So there are a few things that Acting Director Cruz mentioned. I'll just start off with one of the things with regard to the responsibility of the maintenance and the renovation of the clubhouse. First of all, we don't know what the condition of the clubhouse is. We don't know the cost of the renovation. As it stands, I don't believe that CLTC has the funds to do the renovation. And I don't see any reason why, even if you pay the arrears upfront to, let's just use the $9 million as a figure, the $9 million to throw into the renovation will take funds away from our constituents and from our beneficiaries, which we really don't want to do that, which we really don't want to do. That defeats the purpose of receiving the $9 million, is to use it for renovation. So my first ask is that GICC, or the new corporation, fund the renovation to the specs of CLTC. Secondly, we all know that the government of Guam, and I don't mean to insult anyone or make anyone feel bad, but the government of Guam has not been very good about maintenance, building maintenance. I mean, case in point, we can look at, I don't want to name the agencies, but they're in the paper. They've been in the Pacific Daily News and our public papers. So, we know that the government does not have a very good track record with regard to maintenance of their own buildings. Because this new company that's going to be formed will also, I'm quite sure, have their own buildings on site that will need to be maintained. I suggest that including their maintenance, that they continue to maintain the clubhouse and any other existing buildings that are on the property. I think it only makes sense that, we don't want one portion of the property to have a certain appearance and then the other portion of the property, it's like having an HOA. Everybody needs to look the same. So I think that if the CLTC and the tenant can somehow come to an agreement in terms of somewhat of like HOA rules on, what needs to be maintained to, what specification, I suggest that the GICC strongly consider that.
Madam Speaker, can I answer some of your concerns?
Can I just do one more? And so one more is also with regard to the disposition of the solar farm components at the end of the lease, that the lease they specifically say that the disposal will not go into the Guam landfill and should be disposed off island. And then I'll continue as soon as Mr. Carlos Camacho addresses any concerns.
Yeah, so real quick, I just wanted to, if you don't mind, I apologize, and I don't know if I misheard you because of the distance of the audio. 9 million is not going to the clubhouse. Only 1 million is going to the clubhouse.
Zero should go to the clubhouse. Zero should go to the clubhouse. Zero should go to the clubhouse. That's my
No,
recommendation.
let me just explain, if you don't mind. Because when you guys finally have a home and you don't pay rent from your budget, and if you look in the budget bill, you guys paying $100,000 a year, you can leverage that $100,000 a year to get a community facilities loan and grant program to renovate the building. If you know those programs, how to use it. But that's, of course, that's the board's discretion.
Right.
All I'm saying is that when you finally save that money annually, or save, unless you, unfortunately, you guys want to keep renting, that's fine. We can, when we carve out the appraisal, then we just get the appraisal and pay the value to include the clubhouse then, if you guys do not want the clubhouse, right? All we're doing was an ask from the previous board, right? So there'll be a home for land trust. And for the record, the previous board wanted to name that building on the founder of the land trust legislation that founded the law, which, if you don't mind, it was the late husband of the chairwoman, or Medallion.
I didn't ask for it. I didn't ask for it.
But you're great, and if that's not what you guys want to relocate those money for that, then that's your call, and just let us know so we can, that can be always, that's why you have a public hearing, you can get that part amended on the bill.
Yes, so
And remove that part, but that'll be the call at the discretion of the board.
with all due respect, yeah, Mr. Camacho, that's the ask. That's what I'm asking. I feel
Yeah, no,
that this bill,
yeah.
is, when I read it, it's like they're basically, Senator San Augustine is basically suggesting or telling us what to do with the 9 million. And so, I don't think that they're in any position to do that. I don't think the legislature or anyone else is in the position to tell the board or the commission how to utilize the 9 million. I think that's a decision
Actually,
that
if
rests
you
with the
correct,
board.
I stand corrected.
So-
It's not, they're not giving you guys the statutory to use it. It
Yes,
says at
they're
the-
making
you look at
recommendations, so that's, yeah,
Item
that's,
6, it's at the discretion of the board.
yeah, so my
At the
pushback
discretion.
recommendation is that the tenant pay for the renovation of the clubhouse and pay for the maintenance of the clubhouse. That is my recommendation. As the bill stands, I feel that that's what the tenant should do. The other question I have, Acting Director Joey, is the lots that are mentioned in this bill, are those lots already included in the 9 million allocation that was provided to us by the legislature?
No.
Because it seems very specific, and that's to my point, is that the bill is very specific in requesting or suggesting what CLTC does, to the point of giving us, the lot numbers.
So,
And, basically, I think that the board and the people that work for the commission, they probably know best, most especially you, Acting Director Cruz, know best in terms of what is the priority. Is this on our priority list, these lots that are being mentioned?
the only lot that's being mentioned, because I see here 10123 and tract 319 is tract 319. So, it was identified in our proposed projects to sever out the easements.
So it's already included in the 9 million.
For the easements, correct.
Okay. What is this tract 10123?
So tract 10123 is located in Jigo, right in front of Paradise Meadows. As Mr. Camacho had mentioned, this is the only agriculture tract that was in CLTC's property that got rezoned to R1. This tract, and it will be presented to the board soon as we compile all the paperwork, was identified by a previous board to be used for an affordable housing subdivision. The unique aspect of this track is that when CLTC gave up easement to the, I believe, TRI developers, Mr. Mesa, I think, I forget his name, but the people who developed Paradise Meadows, there's an agreement that we have that was recorded that requires that company to survey out the parcels, to maintain the park. So that's why, one of the reasons why it wasn't identified in our proposed 9 million FY 2025 budget. We did at one time go out for an RFI for any interested developers to come in and construct affordable homes. So sooner than later, we will be reporting to the board with our proposed project for track 10123.
There's also a track mentioned, page 2, line item 17, track 319. So there's 2 tracks.
319 is in Hoggett, which is part of our FY 2025 appropriation that we've identified for the surveying of the easements. When we did, Commissioner Garrido and I believe Dexter attended a meeting with the Gura, Mr. Fernando Esteves, to learn about the CDBG DR funds. What drives that is the LMI, the low, medium, or low moderate income category. So for example, like Hoggett, Dedido, and Mariso are automatically considered LMI. So if we were to try to focus on CDGB DR funds in track 10123, how I understood it is CLTC may be required to execute an agreement with GURA that all constituents that are leased or awarded a lease in that track are within the LMI income criteria. So that's what that is.
Since you mentioned the CDBG-GR funds, in order to apply for those funds, does that require a grant writing team and a grant writing packager?
Not necessarily,
How
because
would we do that?
because that is a grant that is within GURA. So that was their responsibility. Although if I'm not mistaken, I believe based on the plan that was issued out, I believe 108 million was identified for infrastructure.
So my question is, the CLTC have the expertise, the staff have the expertise and the know-how to go after these funds? Because yes, we know the funds are there, but there's still the ask. We still have to prepare the ask.
We may not have the expertise in terms of if we have an engineer or not.
So we have to go out and spend more money.
We may
We have to
potentially
spend money in order for us to go after these funds.
We may
So there
potentially
goes
have
our
to.
9 million. We have to renovate the golf course, the clubhouse, then we have to spend money to do the, so we're really not getting the 9 million because we're too busy spending it already. So it's not going directly to the beneficiaries of the CHamoru Land Trust.
Correct.
That's what I see in this bill. Is if we're going to, I think that the, yes?
Audio froze on us again. I apologize. One moment. We're having issues.
But we're still recording, right? Can I
On
proceed?
PBS.
Yes, it's
So,
fine. We
can I
get them.
continue? Okay, so, essentially what it is, in order to do this, to do this bill, or, to support this bill the way it's written, is there's gonna be a lot of spending from CLTC, so the funds that they're projecting for us to receive won't go directly to the beneficiaries, this all sounds nice and pretty, but I feel that there's a lot of directive to the CLTC, and I feel that it's giving up a lot of our, authority with regard to how we can utilize the funds to benefit our primary mission.
Could I add to your thoughts there, Commissioner Bishop, please?
The last thing I do wanna say though, before you add, is that I think that the overall, idea of this project is a very good idea. It's certainly something that, you know, we need on Guam. We do need alternative sources of energy. Just recently, there was another, it was in the paper, there was another company, you know, that, got, I think, a lease award or some kind of an extension to do solar farming. So solar farming is, you know, definitely a need for the island. You know, I definitely support that as a resource for energy for our residents. However, the way the bill is written, in the manner of how the lease will be structured and the lease payments, et cetera, really needs to be revisited. So the overall intent and the purpose to convert the lease, I think, is a very good purpose. I think that it's something that we should move forward with, because it's certainly a need for our residents. However, the way this bill is structured, I think there's a lot more things that we may need to further discuss, so that we can really make it beneficial to the beneficiaries of the trust.
Commissioner Speaker, could I comment on some of your comments?
Yes.
Okay, on regards to the grant and the expertise within the existing body, where you made a potential thought that you may be spending a lot of financial resources to hire a grant writer to take money out. Just to let you know, on the grants, because I've done a lot of grants and all my deals, the grants have called indirect costs. So when you apply for a grant for a value, you are able to charge the grant, not the Moore Land Trust, the grant, the indirect cost for somebody. If that's who you guys want to hire, a grant writer, and you'll get paid through the indirect cost from the grant on the success of getting the grant through CDBG-BR. So if a company A answers to your RFP to help you write the grant, you will be paying it out from your coffers. You can state, and it's done before, you can state that the payment will come from the indirect cost from the grant awarded, not from your general fund operation. So there will be your savings, and you can get that as a technical idea from GURA. Because GURA has a lot of grant writers outside their purview. So that's one way of not touching your general fund. As I'm glad, you know, you're trying to protect every dollar and every cent so that the recipients can use it. And again, if the building is not what you want to direct the funds, then, you know, of course, that's your prerogative. And again, if you notice, the bill says at the board's discretion. So hopefully, if you decide to adopt a resolution like you did in the previous board, you can mention that even though the legislative bill mentions these priorities at the board of discretion, we will fully get the discretion of the board to approve if we're gonna be used for what Joey just described up in Jigo, what Joey described in Agate, and what the bill describes as the clubhouse, at the discretion of the board. And that can be removed and continue if you get support. That's all I'm saying. It's not, it is not legislative mandated to state that you gotta do it. They gave the flexibility from the last debate on the board's discretion. That's all I'm saying. I hope you guys can consider that.
If I may, Madam Chair, Mr. Yohei and Mr. Camacho, when the initial presentation was given, I believe, if I remember correctly, you had presented different funding sources. And one of them was, if I'm not mistaken, not the majority, was the tax credits. So given that I believe President Trump's new budget bill, or whatever it is they just recently passed, had cut a lot of the tax credits related to solar activity, will you still proceed in this? Would you be able to provide another or information related to how the project will be funded?
So I'm glad, Joey, thank you very much for that question. That was a question I think, you brought up in several letters, several months back via, Chairwoman Redalia. So Joey's correct. The, big budget or whatever they call it on the House, they amended the tax credit bill from what was adopted in 2022 when we presented the investment tax, the Inflation Reduction Act. That was under the Biden administration. Of course, the new president and the Republican-controlled House amended that bill to do this, to let you guys know, and it's all public record, that if you don't get placed in service by 2026 or 28, you will not have access to the tax credit anymore. They're gonna retire the tax credit. So Joy's correct. Now, of course, as you know, the House passed that version. The solar industry in the United States lobbied the Senate now. On the Senate version so far that we've seen, because I've been watching that closely, they're maintaining the Investment Reduction Act tax credit, but they're providing a hybrid, and the hybrid is this. What used to be the 30% tax credit, if you don't get your project kicked off by December 2025 anniversary date, then you will not get the 100% tax credit. If your project kicks off after December 31, 2025, you'll get 60% of your 30%. That's being proposed on the Senate version. And what that means is instead of 30 to 18%. Now, how that impacts, what Joy's asking, how that impacts our cash flow, we all know the GPIP, and it's all public record, they put out their RFP at their kilowatt cost per hour at 18 cents. There was another letter that you guys asked, if we could give our pro forma, if you guys could give what we're gonna charge GPA. And the reason why we answered that we could not release that, because anytime we give financial information to a government body, it becomes foiable. Our competitors will see our pricing, our competitors will see our strategic financing structure, and then when we go out on the RFP, then they can bid against us and say, ooh, Carlos team is submitting a 16 cents a kilowatt, let's do ours at 15.5 cents a kilowatt. Then we lose, right? So that's why, for all due respect, we were not trying to hide any financial information to you guys, the request that you did, Madam Chair. We just want to make sure we protect our integrity on our financial data when we submit our bid. After the bid, when we submit the GPA and the bid is closed, win or lose, I can provide those documents for the public record at that time. But what Joy just described on Trump's amendment, yes, the House is amending it in a shorter time, but the Senate version is extending it as I just described. So on July 4th, when the Senate finally adopts the final Senate version, where they send it back to the House to finally adopt it, we will wait and see at that time. In the meantime, why we use a tax credit? The tax credit is to help offset the costs of goods. If our cost was X dollar for dollar, then we have to charge, and we gotta make sure it cash flows based on what GPA is asking publicly at 18 cents a kilowatt. If we are able to layer in our tax credit, then we can be competitive, and if any other competitors come in, we think that our goal is to win, and if we don't win, there's that part in the law here, that, or not law yet, but that if we don't win the bid, then we're back to a golf course. That all solar farm approval will be null and void. So there are a two-way street here. And so just to answer Joy's correct on the Trump big bill tax program. I hope I clarified that.
Yes.
Carlos, I have a question.
Yes.
When you make the profit, Nate, can we get a nice percentage
Add that into the lease.
plus the lease?
Participation,
So,
Huh?
participation.
Yes. Fair is fair.
I think that speaks to
Miss-
Commissioner
yeah.
Respiccio's comments about the bill and how it's directing a lot of things. It's literally almost the terms of the lease agreement.
Right.
It just doesn't include the indemnifying, the CLTC providing insurance and stuff like that. That's why we mentioned in our brief testimony to the board is, you know, to consider, because the board has a lot of responsibility, especially in terms of the benefits for our eligible beneficiaries. Now, for me, internally, and my opinion is, it's kind of alarming that the board will agree to relinquish their authority in determining the lease rate to a certified or a private or a licensed appraiser. Normally what happens, and to Mr. Garrido's comments previously with the Casper Bowers, is 2 appraisals are obtained. The average from that is taken to determine what the rate will be. And based on our new or our commercial rules and regs, a percentage of that will be the lease rental rate annually, right? Just based on this, on the bill, and just thinking straightforward and quite simply and very quick, if you take the 9 million and you amortize it, use a straight line amortization method for 30 years, it comes out to, I believe, $300,000 a year. You divide that by 12, it comes out to, I believe, $25,000 a month. Just on a straight line method, not considering the escalation and everything like that. Today they pay $26,000 a month as of this month, which is greater than 25, right? So, you know, you weigh it out and you balance it. And I'm not saying that I'm against the solar farm activity or anything like that, as Commissioner Respicio had mentioned, although, you know, is it really just compensation and a fair compensation for CLTC? I'll use an example of the Med Farm in Dedido. Although it wasn't this board, it was the previous board that decided they're gonna pay $5.70 per square meter annually. If we go back and calculate and bring it down to what GICC pays today, Med Farm pays more. And their activity there is just using it for a warehouse, for their medical supplies. So I'm not trying to dispute the intent of the bill to amend to allow for a solar farm. However, it's concerning the details and the terms and conditions that are within the bill.
So, Madam Chair, I need your guidance in a motion that I'm trying to formulate. So, you know, essentially what I'm hearing, you know, from today is that there is no opposition from this board. There is absolutely no opposition for the allowance to use the property for the generation, storage, and transmission of renewable solar energy. However, the bill in this fashion, how can I ask for a special meeting so we can address all of the new information that we received from Mr. Camacho, also the acting director Cruz, so that we can really provide, you know, a comprehensive board resolution with regard to the bill, because I don't think, based on what I'm hearing, there's a lot of ideas that acting Director Cruz has come up with, you know, Commissioner Rojas, and also Commissioner Garrido and yourself as well, that if we had more time under a special meeting to specifically address this bill, maybe we could come up with a resolution. So how do I make that motion, or how do I do, or special session, is it called special session?
Work session.
Or work session. So
But just know it-
again, there's no opposition to the intent. There's no opposition to the intent of the bill. It's how the bill has been crafted.
Commissioner Respicio, if I may just know that during the work session, decisions can't be made.
Sure, it's just,
Open
it's
discussion.
it's open discussion, because there's so much new information has already been, you know, shared in the past
I-
20 minutes.
I think, if I'm not mistaken, the public hearing for this bill is coming up. If the board can consider, making a decision that we reach out to our oversight chair.
I do have a question on the work session. Is the work session going to only cater to we, the commissioners? Or will representatives from the golf course be able to participate in that work session?
If you guys open it up to,
Because if we have
Attendees.
questions, they can answer it directly. If we have any idea that we wanna tweak it to go a little bit more to the left or to the right, they'll be there to either acknowledge it or help supplement the tweak.
can be, we just have to plan it accordingly, because again, we're gonna have to publish it on
And
another
and
list.
also, maybe before, prior to the work session, since we do have 3 new commissioners, that Yohei will allow a site visit.
Sure.
Necessary.
Yeah.
We'll make sure that we schedule it individually, not collectively, so that there's no perception of any meetings that are occurring. But if the board members want to, definitely we can reach out to Mr.
Joey, Madam Chair, just to let you guys know, because I'm in Arizona, I understand that 13538 is gonna be heard in July at the legislative session, so there is still an opportunity for you guys to participate in the public hearing down there. So the legislature is moving forward in the July session for this, just to let you guys know.
Don't they
That's
have
why,
don't
if
they
I'm
have
not
to have a public
mistaken, I
hearing
heard the
first?
request was to get into the board meetings, I
So
need
how
to give
can
you guys
they
the
predetermine
opportunity
it's gonna be on the agenda?
to speak amongst you
Without a
board
public
For the
officials
public hearing.
and further speak at the
Schedule the public
legislative, public hearing in July, middle of July, to my knowledge.
Given that Mr. Camacho had mentioned middle of July, that's like the second week of July, we're already on the 3rd week of June. We
Can you
have-
just please clarify when you say it's gonna be heard by the legislature, heard in a public hearing, not for any type of voting or
Correct.
anything?
Well, public hearing,
Okay.
public hearing.
It says
Yeah.
public hearing.
So the public hearing is also an opportunity to change, or, make recommendations.
That's correct, that's
Okay,
correct.
yeah,
It would be more, I guess, it would solidify the board's cohesiveness if
Yeah.
it went down as a resolution.
right.
It will hold more weight.
And so that's why I'm asking, how do I make a motion to have a special meeting, or
Work
what do
session.
I do? Work session, I don't know.
Work session,
I'm
and it's
asking the guidance of the chair.
in 2 weeks to give us time, because we have to, I don't know if there's any
Can we
holidays
fast
coming
track
up.
that? Because 2 weeks
Yeah.
is not gonna, if we're looking at a public hearing in mid-July,
I think that next week, we need to do it next week.
We're not gonna meet the requirements.
What's the minimum requirement?
I think 5 days and 48 hours. We publish it just like how we publish the meetings.
Oh, okay, so then whatever that mark is, that's the day we meet. The 5 days and 48 hours.
5 business days or 5 calendar days?
Business days, if I'm not mistaken.
are you sure? Oh, yeah.
Business days. So like for this meeting, I believe it was published on Friday and a Wednesday, or Tuesday or Wednesday. So, and then we have to communicate with
Yeah.
publication.
So how do I make the motion, Madam Chair, so we can move along on our agenda?
Let me check
Okay,
the calendar board.
so I don't think that we have, when I make the motion, do I have to say the date?
No.
Do I have to say the date?
No, maybe just as soon as possible instead
Yeah,
of the
we
date.
can just say as soon as allowable by law.
Yeah, that's
Okay.
fine. To meet the open government law, that's fine.
Okay,
Then go ahead.
okay.
I'm not gonna give you a date.
Okay, so, help me with my motion. Okay, so I make a motion to request to have a special meeting?
Work session.
Work session to address bill number 135-38, so that we can craft a board resolution, to address this bill. The intent to the extension of the lease term in exchange for allowing the use of the property for the generation, storage, and transmission of renewable solar energy. The intent or purpose of that is clear and is not, there's not unsupported. The work session is for the sole purpose of addressing the contents of the bill, not the intent or the purpose of the bill. I just want to make that clear.
That's it?
Somebody has a second it?
Second?
All in favor, say aye.
Aye.
Oh, and the date would be the most, as soon as possible date
Yes.
as allowable by law.
Right.
Okay.
Thank you.
Thank you very much.
Thank you.
Thank you.
Thank you, Ms. Camacho. Thank you, Mr. Young.
You can go to sleep now. Thank you.
Yes, thank you. We'll see
Good
you
night.
again. We'll see you again.
Good night, guys. Thank you.
Thank you.
Oh, real quick, on that meeting that you're having, are we gonna be invited or no need? So I don't have to worry about any of the schedules.
We will. They didn't restrict it, so we'll extend an invitation to yourself and to Mr. Yogan.
Okay, thank you very much, George.
You're welcome. Oh, we could still proceed. We can still go on. He's here for public comments.
Okay.
So, Madam Chair, we'll move to the next item.
Yes, please. D.
Oh, item D, bill number 6-38, an act to transfer lot 163-REM-PTN-1 municipality indebted to the Special Olympics Guam. This is really informational purposes. We just learned that, I believe it was yesterday, the governor enacted into law. So there really is no need for any discussions. We just provided a copy of the bill. But however, it's law already. We weren't able to get the public law number, but as soon as we do, we'll be more than happy to share it with the board, or a copy of the law. For the next item, item E, bill number 48-38, an act to add a new section to subsection 80.
4138?
4138?
Yeah, 4138.
An act to add a new section to subsection 80-105 of chapter 80, title 21, Guam Code annotated, relative to the transferring of lots 7100, 7102, 7103, and 7146 in Hanum, municipality of Jigo, to the Guam Ancestral Lands Commission. Madam Chair, Commissioners, I am respectfully recusing myself from presenting or discussing any matters related to Bill 4138 due to the fact that Mr. John S. N. Taitno and Mrs. Rosario F. Taitno, named in the bill, are my great-grandparents. I will also be excusing myself from the table and will return once the board has concluded all discussions and decisions related to this bill. Thank you. But Mr. Glenn A. is here to provide any information and that he has gathered related to the lots listed. I'm an heir to the Hanum property, so I feel that it's only ethical that I recuse myself from any discussions.
Go ahead, John.
Okay, good afternoon. Once again, Mr. Cruz had mentioned that the bill, today is Bill 41-38 core, and this was heard on May 22nd, 2025 at the legislature. And again, this bill was to add a new subsection to subsection 80105 of chapter 80, title 21, Guam Code annotated relative to transferring lots 7100, 7102, 7103, and 7146 in Hanum, municipality of Jigo, to the Guam Central Lands Commission. what we'll be focusing right now is, if any questions, the lots mentioned here, CHamoru Land Trust, has the jurisdiction over lot 7100. The rest of them is, Guam Central Lands. So, if you have any question in regards to this bill that, when you request to transfer to Central Lands, I may have some answers for you if you have any questions.
So this land was given to CHamoru Land Trust
So-
from the federal government.
So the history of that, right, and I just got the information, and Johanna's gonna be passing it out to you. I just put it out from the land where it was last minute research. It was really hard to find this information. The story to this in the Treaty of Paris in 1898, and the United States of America. This property, or those property mentioned earlier, was the property of the Spain government, and was owned by the government, and when the United States took over, it was conveyed to United States of America. So this property was already owned by the Spain government, and so what happened was, and there's a jurisdiction transfer from the government of Guam that mentions lot 7100 to CHamoru Land Trust. So that's in our inventory. It is indeed, we have the, I believe we gave you the document 503740, administrative transfer, jurisdiction. On the second page, it shows lot 7100. And also, I provided you a map here that's highlighted, the lot, that's to be transferred to a Central Lands. So the purpose of this is because the heirs of the estate went through the legislature saying that claiming that there was an unjust taking from the United States government, from their grandparents. And, when you're talking about unjust taking and everything, unjust taking is from eminent domain or what have you, and, but this property was not taken through eminent domain. This property was already owned by by the Spain government, was crown land and given to the government of Guam. So there's a big difference between between the taking and property that was acquired by the Spain government. So their claim. So what it is the reason why they're asking that back, in order for the heirs to get the property, it has to be transferred to a Central Lands, and this law says that they'll be requires them to take a look at them and to see if they're the rightful heirs of the estate, and then they'll be distributed to the original landowners. But in research, this one wasn't a taking from the U.S. government. Whereas today, if a land was taken, and then given to government Guam, it goes to Central Lands, and it goes back to the heirs. But this is not the case where land was taken. This property was already acquired by the Spain government.
So basically,
Crown land, yes.
they're asking to move this property to the Guam Ancestral Lands Commission, but I don't see in this bill where it says that it will be returned to the original landowners.
Let's see, dispose of parcel transfer to legislation. Yeah, but in discussion in the hearing, that there's a reason why they wanted to go to Central Lands, because the heirs are claiming back their property. And in order for that to happen, it has to be transferred up to CHamoru Land Trust.
To Ancestral.
To Central Lands.
Okay, so
yeah.
there's no guarantee in this bill
There's no
that ensures us that once we transfer it, that it'll go back to the heirs.
No, this, I don't see any guarantees in this bill, but it's your, the commission's discretion to, you know, if you wanted to, if you want to continue with this bill in favor or not. But I just want to give a little history, why they want to transfer this property to a central land, just so that it can go back to the original landowners.
Unfortunately, they can transfer it to ancestral lands and do something else with it, correct?
Yes, yeah, they can do, but.
Whatever they want.
Whatever they want, but the intent, the bill, because I was listening to their,
Yeah. But
to
if
the.
the intent is not here in black
Yeah.
and white.
Yeah, I was listening to their, the bill, but what they were asking the landowners was paid back, so. Like you said, it's not, the intent is not in the bill, right, but.
I think the main intent of the Ancestral Lands Commission is to return lands to the original owners, right?
Yes.
That's it? I mean, is that
Yeah.
the
Yes,
mission?
that's
Okay.
their mission. That's why, you know, it's going, that's the direction it's going.
Didn't I hear you mention that this was prior, it was a crown property?
Yes, this property was acquired by the government of Spain, not the United States of America.
Return crown lands.
I provided a document here,
Why are we looking at Tectino? If it was crown property?
because that's their claim, their claim.
That's their claim,
That's
that's
their
what they're
claim.
claiming.
You have to prove it's
Yeah,
there.
so if you look at the document that I provided you, document 14402,
I know that
It's,
Tectino's controlled Honolulu area.
So that's why they're claiming.
here it says, let me see, here, that the United States of America having acquired by cession of Spain by virtue of Article 8 in the Treaty of Peace concluded in Paris, December 10th, was that the December 10th of the year of 1998. So this was acquired by cession, they, from the government of Spain, so they didn't, there was no taking, yeah.
So do they have proof of ownership?
Well,
The Tectinos?
there were, the history on that one, again, that they presented to the legislature is that when the United States of America came over and they said that they took it, and they asked the family to do a land registration to the property. And they had a deadline to meet, and because they didn't meet the deadline and they didn't pay the taxes, the property was taken by non-payment of taxes.
Taken by whom?
By the United States of America. That's through their, but looking through this research that I just found today, that wasn't the case. The property was already acquired by the government of Spain.
Well, if it's crown property, it's not local owned.
It's Chamorro Land Trust.
It was a jurisdiction
Any-
transfer.
Any crown
Right.
lands
Goes
goes to Chamorro Land.
This is why it's in our inventory right now.
No,
Yeah.
Any
Not to us.
property that family owns and was condemned by the military
Right.
goes to the
Ancestral.
ancestral land.
Right, you're correct.
so what proof? You know, I don't wanna vote on something if I don't see the evidence. And
This is just only a bill that was introduced. The burden of proof is on the heirs. When they go to central land, says, hey, this is my family property, and that's where it starts.
But
We don't have control of that right here.
But shouldn't we be privy to that evidence so that we can act on it? And
Yeah.
we're being asked to transfer this to ancestral
Right.
based on a claim, but what is the evidence of the claim when the other evidence says it was crown property?
And that's what I just found today, in my research, and that's why I brought it up. I gave you other documents, but I thought this was the most relevant, the most important document that I found that I had to share with you.
Like I said, I know the Tectinos have been in control of Honolulu area. I don't know if it's from a deed or squatting, I don't know, but I would like, there's two sides to a story, this is one side and this is the other, and I would like to see the evidence on the other side.
it's a long,
Why
it's,
is,
it's a long, ongoing thing
I
with
think-
that property.
I think, look at this, it says, lot 7101 of Manuel Guerrero Flores on the south of the beach.
Which item is that?
It's on this,
Oh,
oh,
Yeah, what page are you on, Madam Chair?
it's on the naval government's,
What page are you reading from?
Below,
Page number 3?
the second page.
Okay.
It doesn't have a page number.
Oh, this was their, lot description from way back when.
Yeah.
The whole area of that place was identified as Hanum. So, but when they did the land registration and the decree establishing a title, the lots here I mentioned that what was owned by the U.S. Naval
But
Government.
but I'll say this.
it
The
says
title-
bounded,
Mm.
on the north by the cliff and on the east by the said cliff and lot 7101 of Manuel Guerrero Flores on the south.
Yeah, so it's bounded, it's adjacent to each other, so.
Well, all I can say is the Flores and the Titan is one.
They're one family, yes. That's why when there were the legislature, both the Flores and the Titan was there,
Yeah.
yeah. Mhm.
So this probably is the great
So if I don't have to transfer this property to ancestral, then I would prefer not to. But if we see the evidence that, this is Titanal property, then I would be in favor of transferring it so that they can get it back, which is,
What I heard in the legislature, there was a written testimony by the Attorney General Office and a Central Land, which I don't have a copy of that may help probably, give you a little bit more history.
They testified in favor?
I'm not, they didn't say, they were just their testimony, they didn't say they favor or not. Yeah, they didn't, but it was, everything was, as far as I know, there was no saying in favor or not, but there's a written testimony. They didn't disclose that.
Madam Chair, I'd like to motion that we table this and get more, research done on this before we put it into action.
I'll second.
All in favor, say aye.
Okay, thank you. Hold Joey back.
You have to call Joe.
Oh,
They
yeah.
went to go get them.
So basically on these bills, they're just looking for us to make a resolution. So when
Whether
you
we
leave
support
them-
or not.
Can I get copies of that?
Madam Chair, the next item on the agenda is item F, Bill 51-38. Glenn, can you ask Joanna to pull up the aerial? This bill is an act to amend section 2 of Public Law 34-61 relative to transferring the title of ownership of lot number 7054-1, municipality of Jigo, from the Chamorro Land Trust Commission to the Guam Police Department. Just for full disclosure purposes, I would like to inform the board that I'm a council member for the Jigo Municipal Planning Council. However, I did inform the YMPC at our first council meeting that I will be recusing myself from all discussions and decisions pertaining to the CHamoru Land Trust. So I did not take part in any discussions, any resolutions that may have arisen from their discussions and decisions regarding this bill. So, after reviewing Bill 51-38, we all know the intention is to transfer ownership of lot 7054-1 in the municipality of Gio from the CHamoru Land Trust to GPD. This is the lot, the subject lot regarding in the bill. This is the Gigo satellite game, the power plant. This is Paradise Meadows, so it's right across the street. Initially, based on the 2218, Public Law 2218, this lot, which is known as Lot 7054-4, was reserved for a police precinct. However, DPW was utilizing it, and through 34-61, eventually was transferred to under the administrative jurisdiction of DPW. However, GPD was displaced by the transfer that had occurred. However,
Where did GPA lot rental live?
which one?
GPA,
The lot that GPA is currently using,
yeah, the lease,
right behind here.
okay.
But however, when Public Law 34-36 was enacted, it restored the 3.5 acres by transferring the administrative jurisdiction of the Department of Land Management's undivided 3.5 acres or undivided 3.5 interest in lot 7054-R5, which is this. This is initially was 7054-R5, but when the law was enacted, GPD has a 3.5 acre portion back here. Now today, Public Law 5138 is requesting or is authorizing the administrative transfer from CHamoru Land Trust to GPD for lot 54-1 for the purpose of a police.
And how about the lower lot, the one you said GPD has land there?
Here,
That one?
this area.
Are they gonna retain ownership, or are we doing a land swap?
No land swap. They're gonna retain ownership here, but since 2017, for the purposes of constructing a police precinct and evidence center and all that other great stuff, there still has not been any construction. Now they want this lot to construct a police precinct.
So what are they gonna do with the lower lot? Did that come from CLTC?
It was the undivided interest of the Department of Land Management. It was, I'm assuming it was given to GPD to restore their displacement, because this was given to DPW.
Oh, to restore the displacement, okay.
But today again, our last known activity there was they're restoring tires.
Mountain and tires.
I don't wanna label it that way, but there's tires. So yes.
So I'd like to make a motion. The motion is to support the intention of this bill, of Bill 5138, with the following amendments to include a revisionary clause stating that if the Guam Police Department does not construct a police precinct within 5 years, that the land shall be returned back to CLTC, right? Because it looks like they've had land in the bottom that it's been sitting for who knows how long.
Since 2017,
Okay.
I believe August 17, 2017.
And also to restrict the use of the property specifically to build a police precinct. In section 2, line item 18, it says, including but not limited to a police precinct, so it opens that they can build, I don't know what else they plan to build.
Just to the precinct.
Yes, to just, I mean, if the intent of the bill is for the precinct, then I believe that the bill should specifically say that they want to build a police precinct. But it's in the beginning of the bill, that's what the head of the bill, the title of the bill says, but the content of the bill is not consistent. That's my motion.
I second.
All in favor, say aye. Motion carries.
Madam Chair, the next item is item G, Bill number 73-38, an act to authorize the transfer of the title of ownership and administrative jurisdiction of Lot 15, Block F, Tract 9 in Barragata Heights from the CHamoru Land Trust Commission to the Guam Police Department for the development of a public safety emergency communications center. So the bill that's identified, the lot that's identified in the bill is this. To your left is the Regalio Foundation. To the right, I'm not too sure, it looks like Waterworks.
This waterworks, there
Waterworks.
they're well.
Where's this located?
Barragata Heights. This is the Regalio Foundation. I think this is.
Any other landmarks?
South Savannah Drive.
That's across the antenna, those antennas,
Where's St. Dominic?
on the other
On the other
side.
side. St. Dominic's is right here.
Yeah, it's not on the other side, it's right there.
St. Dominic's. Just go across and it's here.
I don't want the antennas on my house.
And free cable? No. Although,
I'm just joking.
we just want to inform the board, after conducting a quick assessment of the leases, commercial licenses, survey authorizations, utility authorizations, notice of intent to award, and possible pre-occupants within the Barragata Heights parcels in CLTC inventory, we have determined that CLTC issued more land area through the types of documents I just mentioned compared to the amount of land available. The overage amount is roughly 7 acres.
I don't understand what you're saying, what do you mean?
So when we issued leases, we issued notice of intents to awards, we issued survey authorizations, utility authorizations, and based on pre-occupancy on the applications, the amount of area based on all those issuances exceeds what we have in our inventory. How that happened?
So I don't know, what does that mean for this?
So this lot potentially could really may not be available because if there's double slotting in
I
other
see.
lots, we relocate.
I see.
It may be on the land web, when research was conducted, that there is no recorded document that's attached to this lot. But we just have to remember that in the beginning, I believe in 1998, when we started issuing leases, the leases weren't required to be recorded, so it won't capture. NOIAs, survey authorizations, utility authorizations are not required to be recorded, so it won't pull up through research.
What's that building next to the lot?
To the left, the Regalio Foundation.
That's also owned by GPD?
No, that's the nonprofit.
That was our land that we also
Gave to the
gave also,
Regalio Foundation.
the foundation.
Okay, so just given that information that you shared, that the land may not potentially be available, right? But I also support that we do need to support GPD in their mission and what they need to do. I think we need to allow the acting director and his staff to maybe identify other parcels that we know for sure are available. Otherwise, we're just gonna be going around in a circle, right? So if we can somehow have you, look for another parcel that will fit the purpose and the need for GPD, so that they can fulfill their mandates.
Joey, the existing radio towers are there next to St. Dominic's, right?
Excuse me?
The radio towers next to St. Dominic's?
There's some.
Who owns that? Who controls that?
I believe it's CLTC. So CLTC has licenses issued to telecommunications, KM Broadcasting, Sorensen Pacific, I believe Docomo, and GTA, and PBS.
Yeah, PBS, because I remember,
Yes. So
they have like a complimentary lease.
there's an in-kind. In lieu of monetary payments, Mr. John Dares records and provides us services.
And there's not enough room there for GPD?
Based on our quick assessment of everything, all the authorizations we gave out, the amount of inventory that we do have through the public administrative transfer document, the amount of is less than what we issued through the authorizations. So a prime example I can think of off the top of my head is we have a Mr. Kichichu and who was double slotted with a Mrs. Guerrero on one lot in Barragata Heights. That lot can serve as to remediate the double slotting. There are residents of the area who do abut government land who did apply for a agriculture lease with CHamoru Land Trust, and given if they do meet the pre-occupancy criteria, we can't chase them out. They're grandfathered into the program, still on the contingency that they qualify.
Does Shelton's house over, Gilchin Harris house there,
I'm
the
not sure.
second house in?
So, I'm guessing the location at the top of Barragata Heights is the reason they chose this for, but, we know that that lot's available, we just don't know how much of it, is that what you're saying? Or,
Through research through the land web, there is no recorded document attached to that lot.
okay,
However, like I mentioned through our quick assessment, given all the documents, authorizations we issued out, it exceeds the amount of land area versus what we have available. Today, there's nothing on that property, but it doesn't mean to say, like the example I just mentioned earlier of relocating Mr. Kichichu from the double slotting, he may be able to be awarded a lease within this area, or within that lot.
You said that's 7 acres?
3 acres,
3?
yes ma'am. I believe it's 3 acres.
How about the other side, the jungle area behind St. Dominic's?
That side, or to the right? I
To the
believe
right
that's
of St. Dominic.
private property.
I
I think that might be private property.
just don't think, that location is suitable for anything 911, because going up and down North and South Savannah is a struggle for everyone, including the residents, every day, Monday to Friday after 3 o'clock, that is just congested. So, to even, select that location for that purpose is, how is an emergency vehicle gonna exit South Savannah with that long line, especially during, the school days, right? You have the school buses going through there, everybody's trying to get to Bettyville, everybody's trying to get to Chico, so, that's why I suggested that, to give the acting director the opportunity to identify perhaps another parcel that may be more suitable and another parcel that we know for sure is available.
Just also to disclose to the board, during the tenure of Mr. John Birch, a meeting had taken place regarding this lot, and it was mentioned that there'll be a land swap for that 3.5 acres in Jigo for this lot, although nothing has materialized from that.
Oh, so they want the one in Jigo for their precinct, and they want this too,
Yep.
Yeah.
Yes.
for another purpose?
This is for the 911.
that's for the 911
So, but the
center.
other one in Jigo is for
The police
a
is
different,
precinct.
yeah. So why would they do a land swap when it's two different intentions?
Oh, no, the 3.5 acres that was obtained through the undivided interest of DLM we made the,
It's the area where the tires are.
yeah,
Why
that
don't
would,
they put, well, why don't they just start their 911 system there?
I don't know that.
So I'd like to make a motion if there's no further discussion. I'd like to make a motion that the acting administrative director send a letter to the Vice Speaker Ada, who is our oversight chair and the author of, not the author of this bill, but to the author to inform them that CLTC will be identifying alternative lots that will be suitable for GPD's needs while also fulfilling the CLTC mandates. And I believe that we do support the intent of the bill, but not the location.
Does 911 need 3 acres?
Let's just say,
It's
I don't-
supposed to be just, it's supposed to be just a building for calm.
I'm not sure. I do know, if I'm not mistaken, the 911 system for GPD is located currently in the DNA building, if I remember correctly.
they need height.
I'm assuming.
Yeah, I'm assuming they need to put it at a higher altitude, right?
There's, I'm sure we can find parcels, you know, close to the airport and.
How
There's a
about
lot
San
of-
Carlos?
Huh?
San Carlos,
What's that?
by Channel 10?
I'm not sure, but
Do
if
we
the
have
board's,
property out there in that area?
we need to verify. I'm not
Because that's
sure.
high. And it's more like central, so it can hit south and north.
We'll verify, we'll make sure that.
The
we
only
verify.
obstacle going north would be like Mount Santa Rosa if it's line of sight signal, but you know, radio goes up and bounces up from the atmosphere.
Don't go to
Hmm?
Mount Santa Rosa, that's taken again.
No, but what I'm saying is, if we put the 911 up by San Carlos,
Unfortunately, my family's everywhere, but, so there's a motion,
Yes,
she made the motion.
yeah.
I second.
All in favor, say aye.
Right.
Motion
Uh,
carried.
one more thing, commissioners, if you can authorize me, oh, you already said to send a letter, okay, that's fine. Okay.
Now we have the public comments.
Not yet, we have one more bill. The next item is item I, bill number 147-38, an act to authorize the interagency loan from the CHamoru Land Trust Commission to the Guam Memorial Hospital in the amount of $9 million for urgent facility and supply needs, and to establish the terms and conditions of such loan.
Who's the author of this bill?
I believe Senator,
All of these?
I think only the one underlined is
Chris
Senator Salas Mantanani. Oh, no, everybody who initialed. Senator Lujan, Senator Matautau, Senator Schnockstein, Senator Borhoff, Senator William Barnes, Senator Parkinson, Senator Blas, and Senator Dueñas. The bill does provide the details of the loan's terms and conditions. The bill also places the responsibility of structuring and administrating the loan with GITA. However, the bill does not specifically identify what fund should provide the funds for the loan, which places the responsibility on COTC to determine what mandates and projects are sacrificed. I want to give you guys a little history on what CLTC had encountered. What I'm passing to you is the management discussion and analysis of our year-end September 30, 2017 independent financial audit. On the second page, there should be a section there that's highlighted. That section speaks to what had occurred when over time or compounded over years, where CLTC generated funds from the revenue source of at that time, the CHamoru Loan Guarantee Fund and the Survey and Infrastructure Fund. So what happens now is when CLTC's revenues are collected, it's collected through the Treasurer of Guam. At that time, yes, revenues are credited, but the money is not transferred or deposited into the respective bank account, which creates a receivable from the general fund. And over the years, it has accumulated because there was no remittance or deposit of the revenues collected throughout the years. When 2017 had arrived, or when we commenced the financial audit, the annual financial audit for FY 2017, at that time, the government of Guam's financial condition was not great, nor did the government of Guam throughout the previous years display any ability to repay. So when they don't deposit the money, it's perceived as an interagency loan through GASB 34. And because of those issues of not displaying the ability to repay and the financial condition at that time, when we create the financial statements, we have to ensure that presentation and other regulatory requirements are adhered to. So that's the General Accepted Accounting Principles and the Government Accounting Standards Board's pronouncements. So in the end, the money had to be written off and transferred out to the general fund. So if the board should support the loan, not speaking to the financial capability of GMH, if they don't display the ability to pay and their financial condition does not get better, and the board does accept the terms, which is a 1 year with a 4-year rollover, 5 years, if at the end of 5 years, it's perceived as that's the reasonable amount of time to repay and they don't, we may have to write off the loan.
This kind of goes back to our previous discussions, I believe, in the other meetings, that the legislature can appropriate or they can give it to us and they can take it, right?
So anything related to, like, for example, the general fund, right? Or anything that's appropriated in general, right? If we don't use it at the end of the year and the legislature does not authorize the continual expenditures of unexpended appropriated dollars, at least with the general fund, we lose it. But for our special funds, a law needs to be created to amend the law that created the special fund. Because right now, all our special funds or revolving funds are restricted. So I'm confident, and we can consult Attorney Miller, but if this law should pass, because it's broad, it doesn't specifically amend the operations fund or the loan guarantee fund or the survey infrastructure fund, I don't think we have the ability to even loan anyone. Because like the loan guarantee fund, those funds are used to secure on the loan guarantees. It's restricted to for a certain expenditure or purpose.
I thought in our last meeting, we sheltered that 9 million.
We did, but because the bill has not had a public hearing and to afford the board the opportunity to collectively decide what could potentially be the board's testimony, we want to ensure that you guys are afforded that opportunity. But it's not to speak that, because the bill doesn't even specifically speak to the appropriation of the 9 million, however, we could assume that that's what it is. Yeah.
Well, we know that's what it is.
Okay.
I mean, well,
I like to go on
money it could be.
How did they come up with that number?
Yeah, it is that 9 million.
It didn't say 8 million, it didn't say 7, it said 9, which was given to us.
Well, I think just based on the special meeting that we had 2 weeks ago when we took the funds of the 9 million and we kind of directed it to certain projects. And just your explanation of the different funds that we have in special funds, it's really clear that we don't have any discretionary funds. We do not have the discretionary funds available for any interagency loan. So the intent of the bill would also require us to compromise the programs and our progress that we've made just in the short period of time that we've already been here. So, I would just like a motion to recommend that we do not support the intent and the purpose of this bill 14738.
I second.
All in favor, say aye.
Aye.
Okay. We'll prepare a letter and have the
Just
chair
want to know
sign
that
it.
we finish.
Yeah.
Then for sure, yeah, just wait.
Madam Chair, the next item is public comments. We do have Mr. Uggan who is here. Mr. Uggan, if you can come to the table and just sign in, state your name for the record.
My name is Vincent Nicholas Uggan. I reside in CHamoru Trust property up in Derrida, Riverman Road, Washington. I'm here, I already spoke to the Joey, and I updated Agent Glenn. I am a disabled veteran that has a contaminated lung through my duty.
You have a contaminated
Lung.
lung.
During my time in the military, we were deployed into an area where my lung got all messed up. I am characterized as severe COPD. Now I'm getting treatments on and off with the Mental Hospital plus GRMC, but it doesn't help with all the treatment, with all the burning from squatters. Now, in the past, Glenn over there got rid of what, 4 squatters, yeah? That kept coming back to that same land. Now, Mr. Joey here was here with Director Borheim, no? When you guys went up to that property in Riverman Road, right? You were here, right, with that?
Mike Boha or Joe Boha?
See, Mike, right? Where my wife and Castro are the only 2 leaseholders. There are 9 residents. Mr. Glenn got rid of 4, and then the other one, after the typhoon, no? You want them to pack up and go, see down those people, right? So they left, that's number 5. Now somebody else moved in. Now, last month, the firemen came 8 times, all through the day and night into early morning, 5 times. For burning house, burning car, they started forest fire, illegal trap. This is just the lot behind my wife's house, okay? Then we have these other squatters, like as soon as you turn into Nevermind Road on the right-hand side, he doesn't know which uncle, but they gave him permission to stay there. Okay, he's blocking the road. It's an EPA nightmare. There are oil, antifreeze, everything all over the place. Now, this all started with the Haddock?
Jack Haddock.
Yeah, that guy. Because when Mr. Cruz and the other people were complaining, according to Mr. Cruz, he told them that it's not on your lot, don't worry about it. Well, because nothing went further, it got really messed up. When the typhoon hit, Glenn was shaking his head, driving all the way up, checking on all the residents if we're okay. He was shaking his head like, my God, now I can see, all the way over there, man, it's bad. The thing is, my lungs getting worse. I can provide a medical paper from Dr. Ray from GRMC, because they had to do all kind of pressure tests, and they had to take out a piece of my lung to run a test. I cannot just get up and move, okay? When I always try to confront the neighbors and be a neighbor, talk to them, okay? Now, Glenn got the people on our left to burn at the back of their lot, right? So when the wind blows, it only goes onto the yard and not into the house. Then Glenn got the other one on the right to go further down the corner to burn, you know, we all have branches and coconut stuff to burn with. So Glenn got them to do that. We just can't get these guys to do that, to burn away from flooding the house. We have 9 windows. We cannot open our window during the day. We have to keep 6, 7 shutters closed in hope that because the shape of the shutter it can help prevent the smoke and push it outward where it does not go through the window because it's a sliding window, so it goes in between, you know, where you slide the thing, right? It goes through there. The window aircon, it goes through there, and there's nothing we can do about the window aircon. Now, I understand that Director Joey's already trying to get something going, a team with EPA and stuff. I am just here to beg, prioritize my area, please, before that doggone place kills me. These guys are squatters. Our residents that are there legally, when the sun's about to go down, when you see them walking, elder people carrying a chain, that's the type of people that are rushing in and that the people there are not feeling safe. This year alone, our neighborhood, the same place I'm talking about, right behind my wife's house, was raided 5 times for drugs, stolen vehicle, that 3 sibling that they were chasing for the kidnapping and all that. Yeah, that's where they're all hiding. GWA's generator, they found out it went over there. There's a lot of things, just that area. Okay.
When you say they're squatting, are there shelters there that they're squatting, or they're just camping out?
Okay, they got broken bus. They try to stay in there. And then they're putting out canopies. The other side, same thing, another broken bus. Palapala, how do you say palapala in English? Anyway, palapala. Canopies, right? Canopies, okay. That's all they do. Now, one of the neighbors was saying the one in the back is renting the containers. And no, you can't rent. CHamoru Land Trust, they have a deal with the person that lived there last. So I'm like, shit. No, I'm sorry. Our water pressure is so low. Every time GWA come out, it's the illegal taps coming from the one on my left and the one behind my wife's house and further up. And they're like, they cannot do nothing but disconnect and then come back and to re-disconnect because they have nobody to point the finger to. Now, I don't know, because a lot of people are scared to talk. I don't know, the doctor told me I got about 7, so hey, they got 7 years to come to me. But I'm here to ask, please prioritize. You guys don't have the staff to go to all of these abandoned property. You guys are not police officers to patrol these properties. But use us residents that's there complaining as your eyes, because we see it. You guys don't own security guard company to be guarding these properties. I understand that. A lot of us residents understand that. It's just, we need help. And the only way we can get help is to help you guys be your eyes and ears. But if that falls on deaf ears and a blind person, you know. Well, there it goes, you know. But I cannot sit here and say Director Joe and Glenn is not doing their job, because they have removed squatters from there, but they're just moving in faster than they can get them out. 2 of them, they kicked out. Director Bora kicked out. Director Hattie put them back in. Then somebody went there, beat them up. They moved out. Then they're back again. And I'm like, you know, a lot of us there are senior citizens. The only one you find there younger than senior citizen, or the senior citizen got babysitting their grandkids. Other than that, they're just squatting. Fire truck has a hard time coming up because all this chop shop coming up Nevermind Road. All the abandoned vehicles are like these. They have to beat the horn to try and get these people to, hey, push that car in. And there are fires. That's why they're there, because we're calling in all this fire that are smoking us out. Got to the point, sometimes the ambulance go up there, they come check me. So they already know, check the organs, you know. I have a standby oxygen machine. I don't like to use, because, you know, people see me dragging a bottle around and pulling this, you know. I got a wheelchair now. It's I don't like using my wheelchair, so it makes me look namasi, which I'm not. I am asking you guys, please help us out over there. So it's not good. Okay, now, like I said, Glenn's been up there a lot trying to talk to them, you know. There is a process, I understand. I'm not here to tell you, you guys don't know what to do. No, I'm asking you, can you please just push a little bit harder towards our road before all this thing gets somebody killed. There's some people that are so mad because the way their parents are getting treated, they want to go beat these people up. And I was telling you, right, land is going to turn into a war up there, man. There are drug peoples up there. 2 o'clock in the morning, who there? I'm sorry. Who bush cut and blow leaf 2, 3, 5 o'clock in the morning? Our house is right next to the road. When I told this guy stop from burning that thing, so it's coming into our house, even if our windows are closed, he turned around and told me, well, I didn't tell you to build your house. This is the squatter. I didn't tell you to build your house. I started heading towards him. You step into this property, I'll call the cops. I kept going. Then my wife got mad. She's in charge, so I looked at her like, I know, dude. Then next thing I know, the cops came to tell me I cannot enter that gentleman's property, and I told him that's not his property. That gentleman, there was people back there, the kids that he moved in there, and his cousin that he moved in over there, and this other guy, they don't own shit back there. If you have a problem with the landowner, CHamoru Land Trust. Okay, now, I told the cop, CHamoru Land Trust trying to clean this place up, just that they're coming back faster than they can get rid of them. So, like I said, I don't blame Glenn, I don't blame Joey. They're just coming back too fast. You guys are not cops, you guys don't patrol these places. But we're there. If you guys would listen to us, man, you guys got the best patrol officers. Why? Because they don't want this crap in their neighborhood. Every time there's a burning, either we have to go to a hotel or go up to my stepdaughter's house, which is that water pump right outside the back gate of Anderson, you know. And that's from Nevermind Road, trying to drive all the way up there because they're burning 1 o'clock in the morning, so we can't get choked out. Okay. That's all I have. I mean, I know there might be nothing you guys doing, but I'm begging you guys, please come up there and get these people straightened out, so.
So if I may, Mr. Ugin was here last week. We've already started to plan and started developing the aerial map of the area that we're gonna concentrate on. So next week, Tuesday in the afternoon, what we're gonna do is do a compliance inspection sweep of the whole Nevermind Road on the left and right of the street down. There's maybe about 13, 14 houses probably, if not a little more. It's something we can complete within that time frame. But again, we're gonna do the same process we do for everybody and give them a notice to remediate. If the individual who's there at the property at that time, we take note of who it is and we determine that that's not the actual individual that should be there, we will definitely do our part to try to contact the individual that's supposed to be there, to determine what's the arrangement, if there is an arrangement, or if that individual's deceased and the one who's there is the child. We don't know, but definitely we will find out, and definitely we will be there Tuesday next week in the afternoon to do what we need to do. If in the event that we should encounter any type of resistance, definitely we will alert GPD to assist us in whatever we're doing. But like Mr. Ugin had mentioned, throughout my years here, or even prior to Mr. Mike Borja, we have visited that area a lot. But we are doing, so you know, Mr. Ugin, we did consider what you had disclosed to us. We had planned, we've already mapped it out through an aerial map. We've identified your area and it's already on schedule.
Thank you. Sorry I took up your time, and you guys have family too, but I just want to make sure, man, I put it on record because I have what they call severe PTSD. I have an intermittent explosive disorder. I'm being medicated for it. What my wife is scared of is I trick her that I took it, and then that never pissed me off 2 days down the road. It's not a good thing. It's, you know, I mean, the VA keeps track, you know, every week. I have to display my medicine so they can count it and shit, but it's just not good. Okay, I'm sure a lot of people out there got bigger problems, but this is my problem that I'm trying to get resolved. I've been coming here since 2000.
Maybe.
So what do you think is the
Solution.
yeah, the solution or the remedy, the permanent remedy? If these people are there, they're not supposed to be there, are those lots already leased out to other
They
people?
potentially could be. Majority of the lots in Dedido are,
Okay,
especially along the Wysing Song, Nevermind Road, Swamp Road. Either it's leased or it's being occupied by possibly a preoccupier, or occupied by a descendant of someone who has a lease. Potentially, if I'm not mistaken, I believe the whole left and right side of Nevermind Road has been leased out.
so what can we do more? I mean, do you need more funds to enforce? What do you need that, you know, to help people like Mr. Ugin?
Well, I believe if we mitigate the issues of the surrounding lots, it would resolve itself or resolve Mr. Uggin's situation. However, we'll go and discuss with Attorney Miller what can be done. Alerting EPA, I'll give you an example. When the dengue fever was, I guess, was a concern in Swamp Road, DPW came in. They, I don't know, took out I think 400 cars if I'm not mistaken, if not a little more. I don't think less. The following 2 weeks, that area where we were at, it was twice as bad.
Yeah.
So, you know, and like we mentioned when we were discussing the appropriation of the 9 million of track 1022 where the illegal dump was occurring and the fire that happened, one way to mitigate, at least at no cost to CLTC, is getting the presence of our lessees there. So by installing infrastructure, making it available for them, that may create some kind of initiative with them to avail of the benefits of leasing property from us. But, you know, but definitely I'll consult with Attorney Miller and see what can be done. Definitely, EPA is very responsive to us, issuing their notice of violations, but that doesn't stop them. They'll do it again and again and again. I think they won't be able to do it if they went to jail, right? But because they're absent from the place, but you know, nonetheless, that's like really far-fetched and way in left field, but we'll discuss with Attorney Miller what mitigating factors we can implement. But again, it's gonna require an amendment to certain laws or introduction of a bill and things like that.
I mean, look at, like his sons, you get one up, two moves in.
I'll give you guys an example when
I'm
in
joking.
the land where behind La Familia, there was a family here that was evicted and removed. 1 week later, they moved to the lot on the other side. They just took the and moved over. So, you know, it's difficult. We can do everything legally, but I don't know the answer right at this time. But definitely we'll do our best.
So, you guys don't own, you know, security company, and you guys are not police officers. Hard to catch these people. You need the neighborhood. The neighborhood can tell you, you know, who's doing what, you know, who's going what school, what, because back then, we used to watch each other's kids because that one's not gonna come home from work till 4 o'clock. Okay, all the kids go. I used to have kids come over to my house from elementary because my granddaughter, so they all stay there. We help tutor them, make them do their homework and stuff until their mother come get them.
So this area where Mr. Uggan lives, is that area paved?
Yes.
Okay, so it's already paved in and they have the utility kits.
The main drive is paved. Then you have your dog legs,
The secondaries are not,
yeah.
just the main.
Yeah.
Joey, how far does Nevermind Road go?
In?
About a mile.
Yeah, maybe a mile.
So
Just a mile?
is this lot area, is that on our list of, to-dos in terms of paving all of the secondary roads and bringing more resources?
Not in the recent
Not in the
discussions.
recent, okay.
Where exactly is Nevermind Road?
So if you're heading.
Can you pull it up real
Yeah,
quick,
we'll
or?
show you.
The,
It's right
See
before
his
Swamp
lot.
Road on the right.
yeah,
If you're
it's in the
heading
little Westing
towards
Yeah.
UR Market.
Next to,
Oh,
next to, Tanaka's,
No,
right?
No,
Shocker.
that's-
You know the Shockers?
No, I don't.
You know La Familia Market?
Right across.
Right across, there's a bus stop there, that's.
Because if you
Nevermind.
think that bringing in, you know, more resources like
Samsung
paving
Road.
and things would help, I think that we need to get it done.
Nevermind Road is one.
Oh, sorry, my back.
Yeah.
So here, this is
Espargaro Heights.
I saw that familiar. Can you zoom out? So this is Mr. Uggan's wife's leased area. The area of concern is over here.
Yes.
So this is Nevermind Road.
Okay. So the road.
See the
leading in-
one with the one that actually has a yard? That's my wife. The other
You
one,
see the license on-
the other,
So
all
the road in
trash.
front of Mr. Uggan's house, is that paved?
This is paved.
Yeah, but no, not the one in front of his
Mm.
Not the
house.
secondary.
That's secondary, okay.
That's my wife's lot,
And how far in, Joey?
Hang on, they're gonna.
about 2/3 in, yeah?
his wife sings on, so
Yeah.
For a
about a
second.
mile maybe.
Are people afraid to live there?
They
Mr.
cannot
Alden?
go nowhere.
Huh?
They cannot relocate. They're, how do I explain this, Glenny D?
They already have their properties there, so
Yeah,
why would they,
they're
yeah, they have their
they
leases, why would
built-
they leave? Yeah, they've done
Yeah,
the
they built
investment.
their house and everything.
So I
but-
think we need to really put that as a priority also, you know, I mean, with all the funds that we could potentially also get with, golf course. We don't wanna use it to rehabilitate our own offices, that's my point. Cause we have so many opportunities to help, you know, communities like where Mr. Uggan lives, to help pave those roads and to help bring better resources to these families and, you know, these beneficiaries. So why would we use those funds to, you know, to fix up an office for ourselves? You know, that's my whole point in that.
Understood.
Is that the dead end there on Nevermind Road?
No, it's down further. It's not that far down.
It's further down here, but,
It's right there. It's not far.
and it goes, extends further down here where there's no improvement. This is where the improvement ends right here.
Yeah.
But
This is where power and water ends right here, not available down here.
No, but what about that area is,
This one?
yeah, going down?
Here?
That green area, is that still CHamoru?
Yeah, this is all CHamoru Trust. There's schemes, I believe, for certain areas, if not here, further down, that has been developed, which is, I believe, this one, or this one.
The nugget right here, the 10 acres, right here.
So there's schemes that have been created, gradually we'll get to those areas. So this is La Familia store, if everybody's familiar with that, head north, it's the first paved road, right turn, there's a bus stop.
Where's, Tanaka's branch?
There's
that's up
further
swamp,
up
yeah,
north,
by swamp area in there, but to the left, no?
No, to the right.
To the right?
So not like, that goes in from, further up to Swamp.
Swamp Road.
So Swamp Road is about, yeah,
Yeah, so Tanaka's on the,
So where's the back end of the golf course?
down,
yeah, Batilla.
right,
Right there?
here,
Yeah.
this is the golf course.
But I just wanna thank you guys for giving me the time to speak.
Thank you, Mr. Uggan.
I gotta get home, so my granddaughter is babysitting my wife. This is charging me $20 an hour.
Before we adjourn,
Paradise Estates.
oh, no. Thank you.
So that's
Okay, yeah, you're good. Before we adjourn, Madam Chair, or consider, I'll just give everybody a copy of the draft MOA that was sent to DLM. Sorry, I was supposed to pass it out earlier.
Could you give us the copy of your notes for the GCIC bill, the one that you're reading, because we need that when we do our special, when we do our meeting.
I'll prepare it.
We need to end our meeting.
I really did it shorthand, so it's,
Chair, motion to adjourn.
Second.
All in favor, say aye.
Aye.
what time is it?
The time is,
6:08.
oh my
That?
gosh, 6:08.
So, Commissioner Ross will